Hmm.
24th, my lord, the respondent authority is going to allow to make the advance payment by someone else. Whereas I was the highest bidder of 12.73 lakh per year. But without any rhyme, showing any rhyme and reason, that was not accepted by the authority. And against fresh tender and auction was called. And
When was the financial bid was open?
yes, my lord.
When the financial bid was open?
My lord, that was opened, and my lord, an agreement to 14th. I lost the complaint immediately on 11th, but 14th, my lord, a agreement has been executed, which will be given effect from 24th after allowing to make payment. So, my lord, still now it is not, and my lord, it is the auction bid. My lord, open auction bid was there.
No, once the work order is issued, what remains in the tender?
No, my lord. Here, my lord, the main thing is reduction of the minimum price, minimum reserve price. My lord, it is totally arbitrary. Whenever I quoted 12.73 on the earlier auction without showing any rhyme and reason, that was not accepted. But within 15 days, my lord, the fresh tender was invited and auction was done on 9th March. And my lord, the reserve price was, my lord, below 9 lakh. When I was agreed, and I was, my lord, disallowed because, my lord, whenever I was going to make the
So, now what you want?
My lord, I want let the matter be taken up, my lord, on Monday. My lord, 23rd.
23rd already, so many matters.
My lord, kindly, my lord, because 24th, my lord, it will be, my lord, payment will be allowed, my lord. Kindly, my lord.
Okay. Allowed?
On
Lord,
Monday, 23rd, within 10 matters.
I am deeply obliged to your lordship.
Lord, may I have your lordship's kind leave, Lord? Am I audible, Lord? Before your lordship, Lord?
Yes.
Lord, may I have your lordship's kind leave, Lord? Under extreme urgent circumstance, Lord, I am disturbing your lordship. Lord, may I have your lordship's leave, Lord, to file a writ petition today and, Lord, move it at 1 p.m.
Why? What urgency? Urgency.
I tell your lordship, Lord, the reason is, Lord, the resolution plan has been granted in my favor, Lord, where the committee of creditors consists of, Lord, only 3 operational creditors. Lord, Punjab National Bank is the majority stakeholder of 94 to 95%. Others are, Lord, insignificant. The resolution plan amounts to, Lord, 22 crores and odd. Now, Lord, I was granted a certain period to, Lord, comply with that particular, Lord, plan. Now, the difficulty is, Lord, in the interregnum, your lordship knows, Lord, the international market. Because of that international market and the Iraq-Iran war, Lord, Iran and US war, Lord, the entire, Lord, raw materials, Lord, whatever my funding was, all has stopped.
What
I had prayed for before the, Lord, Punjab National Bank is not only a extension of 6 months so that they will charge interest on that 22 crores, no difficulty, but only an extension of 6 months because of these peculiar circumstances, Lord, so that it can enable me to, Lord, enforce that, Lord, resolution plan. I am, Lord, on behalf of the director of, Lord, the corporate debtor. That's the difficulty. Lord, I am an MSME. I am trying to save my business.
So what is the urgency now?
The urgency is, Lord, any day, Lord, they have a bank guarantee. They may invoke, Lord, that bank guarantee upon, Lord, cancellation of that, Lord, resolution plan. That's the only difficulty, Lord, nothing else. I am not shying away. I am not going away anywhere. I want to secure the interest amount of, Lord, that 6 months in addition, whatever they are giving me, willing to give me. I'll secure that interest. At the best, Lord, bank will get interest, nothing more than that.
Possible, Mr. Kamaka. Today it is not possible.
Lord, I understand your lordship's difficulty. Your lordship is overburdened, Lord. But the difficulties, Lord, that the bank guarantee might be invoked, Lord.
You affirm the writ petition.
Lord, it's there, Lord. It's my junior is there, Lord.
Affirm, and if it is placed supplementary at 2 p.m.
I'm grateful, Lord. Deeply obliged.
Regarding 661, my lord. Regarding to item number 661. Upon mentioning your lordship, consider the urgency matter directed appear today.
Huh?
Upon considering the urgency.
What is the urgency?
Urgency, I am being selected.
Selected in?
Selected for giving a plot. I have been directed to submit the document, submit the money. I am deposited. Suddenly, by email by order my application cancel.
Okay. Come on Monday. Come on Monday. Monday is the yes. Next, call the list. Nobody's appearing. Though the matter is listed to be mentioned on receipt of the urgency receipt from the learned advocate of the petitioner, but when the matter is listed and called today, none appears on behalf of the petitioner. Let the matter go out of the list.
My lord, I appear for the petitioner, my lord. An application, my lord, for extension of interim order CAN 4. My lord was pleased to pass an interim order, my lord, which is till 23rd of March. My lord had also given directions for filing of affidavits, which has been served upon us belatedly, my lord. My lord, so your lordship kindly gives us 2 weeks time, my lord, for filing the affidavit and replying the interim order.
When you receive the affidavit in
my lord, on
opposition,
17th of March.
so why you not file the affidavit?
My lord, your lordship had directed to the affidavit of opposition to be filed on 26th of February. We have received it on 17th of March, my lord, belatedly. 2 days ago, my lord. Today we are on the 19th, 20th, my lord. Your lordship would kindly grant us, my lord, 31st March. That is the 2 weeks from the date of receipt of the.
Yes, my lord. That I have.
My lord, and your lordship
The
would kindly, my lord,
matter is
extend.
May I
the
pray
interim
only
order.
one thing, my lord?
Yes.
My lord, any day may be fixed for hearing of the matter.
So then in May, if you want a specific date and time for hearing, then it will be fixed in the month of May. Before May,
Let-
My lord, actually, my lord, we are
if you want to hear the matter, taking chance, then it will be listed as urgent motion. If you get the chance,
Yes,
you can argue the matter. It is up to you.
Yes.
Fix it on
Which choice you want? There are two choices.
Fix it.
Either
on
fixing in
21st.
month of May,
Urgent motion, my lord.
urgent motion. The
Your lordship may
can
kindly.
for you filed.
My
Can
lord.
for
CAN 4, my lord, is for extension of interim order, my lord.
the matter is listed as to be mentioned on receipt of the application filed by the petitioner.
My lord would
Can
kindly consider
4 of
page 20, my
2024,
lord.
2026 for extension of the interim order. Counsel for the petition submitted the interim order is till 23rd of March 2026. He submitted by an order. The petition has received the affidavit in opposition from the respondents only on when
17th of March. 17th of
2026,
March.
and as such he requires a week time. A week time
My lord, till 31st, my lord, 2 weeks.
requires 2 weeks time to file affidavit reply. Full stop. Let affidavit reply be filed within 2 weeks.
My lord.
Full stop. In 2 weeks, list the matter on 22nd April 2026 under the heading urgent motion.
Lord.
One urgent motion.
Lord, the interim order may be
The interim
extended
order is
till October,
extended till 24th of April 2026
No,
or
no, no.
until further order, whichever is earlier. CAN 4 of 2026 is disposed of. Come on, 21. Interim order is 24.
24th.
Next.
I appear for the petitioner, I appearing item number 4, lordship led by Mr. Amal Kumar Sens.
Which was the
I
three?
appear for the respondent number 5, my lords, in item number 3.
Both the matters were taken up together, but probably that extension of interim order has not gone down.
Not
All our
one.
friends were there. But your lordship was pleased to extend the interim order till 10th of April.
Which item number? Both.
Both were taken up together. Common order was passed.
But this interim order, my lords, is in item number 4.
Item number 4 is 15798.
15978.
Yes, my lord.
Order is single, na? Red order is there.
Interim order in item number 4.
Earlier it was interim order was there.
Yes, no, there was an interim order.
By which order?
My lords, it is order dated 5th of February, when the matter was listed together and the common order was passed in that.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Police counsel for the petitioner submitted the petitioner was enjoying the interim order, and the matter was taken on 5th of February 2020, 17th of March 2026. And this court has passed an order, but inadvertently the interim order was not extended. Accordingly, placed an extension of interim order. We have the submission made by the counsel for the petitioner of the interim order is extended.
ওনারা যে ক্যান টু ফাইল করেছেন আপনাদের সার্ভ করেছেন
Police fixed on 30th.
Lord, it's
Yes, my lord, it is being fixed for 30th.
Interim order is extended till
this
6th of
30th should now be 7th April.
7th April.
Has to be 7th April, Lord, as mentioned in the earlier one.
Is extended till 10th April 2026 or until further order, whichever is up there.
And when in item number 3,
Yes.
the last at page 2, paragraph number 5 records the matter, directs the matter to be listed on 30th March. That should be 7th April.
In the order dated 17th March 2026, in paragraph 6, the date shall be read as 7th April 2026 at 12 p.m. instead of 30th March.
বাকিটা তো ঠিকই আছে।
Next.
গ্রেটফুল
Deeply obliged, my lord.
Yes, next.
Item number 5 and 6, Lordship, I am appearing for the petitioner. Petitioner want to withdraw the petition, Lordship. I have instruction from my client, Lordship.
I am for, my lord, the distribution company limited.
I am for the private distribution.
Tomato, 5 and 6.
WP number? Huh? 3795. Yes. Your representation. What is the writ petition? 3627. That is not here. See the written communication. What is the written number?
There is some printing.
So how it can be?
The number may be wrong.
That is one writ petition. What about the other? Both is Sri Ma, engineering law. But there is no two applications, two numbers are there. You are the advocate on record. You are the advocate on record. Who is the advocate on record? Where is the file?
Number may be wrong.
Who is the advocate on record? Who is Ankita Chaudhary? You? Who is Ankita Chaudhary? Who is the advocate on record? Whose वकालतनामा in the file? ये दो, ये क्या है? ये भी तो एक पढ़ो. पढ़े. दोनों 3628. How you got this number 3628?
That may be the filing number.
No, W. কি আছে? दो फाइल तो 3795 and 3803. এটা চেক করুন সিস্টেমে WPS 3628 WPS 3628 of 26. Three six two eight of 26. কি নাম আছে? Rabindranath. You correct it. You do one thing I am keeping on Monday. Correct it, come on Monday. Not today. Correct the writ petition number. Yes, next. Yes. When it was dismissed? 24th April 2025. Huh? বলছি আমি कुछ I do not understand anything what you have submitted. Why you not appeared on that day when the matter was called? Huh? What is the, where is the cost shown in the application? Why you not appeared? Where is the cost shown in the application? The petitioner has filed the present application being Can 1 of 2026, praying for recalling of the order dated 24th February 2020, 24th April 2026. And April 2025, matter was dismissed for default. And when you file the application, February 2026, where is the justification? Where is the justification of delay? You have not shown the cause. Okay, no problem. Where is the justification of delay? After about 11 months you have filed. Where is the application for delay? Record or not. The petitioner has filed the present application for recalling of the order dated 24th April 2025, wherein this court has dismissed the writ petition for default for non-appearance of the petitioner when the matter is called. The counsel for the petitioner submitted that the petitioner was not aware whether the matter was listed before this court on the date fixed, and as such the petitioner could not appear before this court. And as such the petitioner, when the petitioner came to know that the matter is dismissed, petitioner has filed the present application. Consider the submission made by the counsel for the petitioner. Peruse the record. This court find that the order was by an order dated 24th of April 2025, the writ petition was dismissed for default for non-appearance of the parties. But the petitioner has filed the present application for recalling of the order dated 24/4/2025 on 19th of February 2026. That is almost after 10 months of the order. but the petitioner has neither filed any application for condoning the delay nor has shown any cause why the petitioner has not appeared before this court when the matter is called, and why the petitioner has not filed the application within the prescribed time. Thus, this court did not find any reason to recalling the order dated 24/4/2025. Accordingly, can number so and so dismisses. Next. Next.
Item 8, my lord, I am appearing for the respondents.
Yes. Who is for the petitioner? None of person. Why today's ये application में क्यों आया आज?
Restoration application, my lord.
Petitioner.
I am the respondents, man. I am for the respondents.
हाँ. Hmm. Hmm. So why you not appeared on that day? The petitioner has filed the present application being Can 1 of 2025, praying for recalling of the order dated 18th September 2025, wherein the writ petition was dismissed for default for non-appearance of the petitioner when the matter was called. Counsel for the petition submitted this court has dismissed the writ petition for default on 18th of September 2025. Immediately on 26th of September 2025, the petitioner has filed the present application. He further submitted that the matter was listed in the monthly list on 18th of September 2025, but the list was immediately collapsed, due to which the petitioner could not able to appear before this court. Had the counsel for the petitioner produced the application, this court found that the petitioner has shown the sufficient cause for non-appearance before the court when the matter is called on 18th of September 2025. Accordingly, order dated 18th September 2025 is recalled. WPA number 3854 of 2023 is restored in its original file. Can number 1 of 2025 disposed of. List the writ petition on 22nd of April 2026.
One kind indulgence, my formal objection may be recorded.
Land counsel appearing for the respondent raised objection and submitted the petition has not shown any cause why the petition has not appeared.
Deeply.
Let me see what is happening in that matter. Yes, next. Huh? As per the prayer made by the counsel for the petitioner, cases adjourned, let the matter appear on 2nd April 2026. Next.
But item 10, I'm appearing for the state respondent, my lord.
Yes. Yes. What is your grievance? So what you want? Where is your application? Restoration application. You not filed the restoration application. Have you filed the restoration application? Where is that?
Restitution application.
কোথায় আছে? Application আছে কি? কোথায়? Have you served?
Yes.
Have you received?
Yes.
Give the copy.
Yes, sir. Yes, sir.
What case you have filed against the Registrar General of Calcutta High Court? What is your prayer in the writ application?
My lord, the honorable division bench set aside another honorable division bench order. So, as per
Who are you?
I am petitioner in part.
What is your prayer in the writ petition? What you have prayed for in the writ petition, sir?
Here, my lord, it is larger bench matter. Please refer to larger bench as per honorable Supreme Court judgment.
Direction to proceeding or consequential action. Hold and declare that the assumption, access, jurisdiction of the impugned proceeding where such not been invested ab initio. Declare continuation of the. Okay. What is that? Why you are not appeared on 5th of March?
My lord, I appear first session on 5th day, March. You directed me application submitted to court official. আমি application দিয়েছিলাম.
That is another thing. But you, when the matter is called, why you not appeared?
My lord,
5th March, the matter was there.
Appear from illness.
Due to illness, you not appeared. So,
first প্রথমে আমি appear হয়েছিলাম. মর্নিং সেশনে প্রেজেন্ট ছিলাম. I present this court.
So why if you are present before this court, why your application is
second half I go to house my second half আমি ছিলাম না my lord. Item number 62 ছিল.
That's why you were not there in the when the matter was called. Morning hours you were in the court.
Morning hours, my lord.
You mentioned the matter. The matter was in list.
Permission.
Okay.
Please consider my.
Yes, madam.
But lordship, other allegations have been made in the writ petition.
I will recall that.
In the application also, in the restoration
I will
application, we are not using any affidavit, lordship. We are not
I will
doing anything.
The petitioner has the petition.
Hello, affidavit ready, my lord. Affidavit.
Huh?
Affidavit file. Affidavit.
Yes. The petitioner is present in person. The petitioner has filed the present application being Can 1 of 2026. Yes, Mr. Chatterjee, anything?
Madam, formal objection may kindly be noted, madam.
The petition is present in person. The petitioner has filed the application being Can 1 of 2026, praying for recalling of the order dated 5th of March 2026, wherein this court has dismissed the writ petition for default for non-appearance of the petitioner. Police counsel for the petition and the petition submit that the petitioner had appeared in the morning hours, but due to some personal difficulty could not appear in the second half when the matter was called. And as such, when the petitioner came to know that this court has dismissed the writ application, the petitioner has filed the present application for recalling of the order. Police learned counsel for the respondents raised objection and submits that the petitioner has not shown any cause why the petitioner has not appeared, and as such the petition filed by the petitioner be dismissed. They further submit that the petitioner has made several allegations in the present application, though the petitioners have not, and though the respondents have not used the affidavit in opposition, the same may be treated as denied by the respondent. Consider the submission made by the counsel for the party. Consider the submission made by the petitioner in person and the learned advocates appearing for the respondent. This court finds that the petitioner has shown sufficient cause for non-appearance before this court on 5th of March 2026. Accordingly, the order dated 5th of March 2026 recalled. WPA 2556 of 2026 is restored in its original file, as the respondents have not filed affidavit in opposition at the very application has been disposed of at the motion stage. Accordingly, the allegation made in the application deemed to have been denied.
My lord,
But in this matter, I'm led by Mr. Samrat and
my lord, it is larger bench matter, neither a single bench nor a division bench.
Okay, I will take the matter. One day I find that it is a larger bench, I will refer to the larger. There's no problem. Let the matter.
It's judgment, honorable Supreme.
Correct. I will fix the matter. One day your application is allowed, writ petition is restored. I will fix one day. You come on that day. You satisfy this court. This court cannot hear. I will refer the matter. There is no problem at all. List the writ petition on 24th April.
Lordship.
24th April.
Sorted, my lord, from 2009.
10 April. 10th April.
My lord, this matter I'm led by Mr. Samrat and Lanasini, advocate, my lord.
Give the name in the chat box.
Lordship.
Yes.
I'm grateful, Lord.
13, I appear for the state lordship.
Yes.
I am for the petitioner, my lord.
And I am for the WBSCTC.
But I have challenged the decision-making process of the authority in awarding one of the work in favor of a person. Me, my lord, he is the one of the favored. But your lordship kindly come to my lord. Annexure P2, page 35. This is the notice inviting.
35.
Page 35, annexure P.
Yes.
Pursuant to that, I responded.
Notice 16 January.
Yes. Pursuant to that,
Shifting of electrical lines and utilities.
Yes.
Okay.
Pursuant to that, 4 bidders offered their bid.
Hmm.
And my lord, according to the bid opening day, that is 2nd February 26, the bids were open.
Hmm.
Then my lord, your lordship kindly turned to annexure P3.
When the bid was open?
On 2nd February.
2nd February bid opening. Yes.
Bid was evaluated or assessed on my lord that day. Ultimately, it was assessed on 11th February 2026 on page 125 annexure P3.
125.
My lord. But the tender evaluation committee was formed and they considered the bid, the entire bids submitted by the 4 tenderers.
Correct.
Your lordship kindly, after the box, your lordship kindly.
You are not there.
Yes, I am there.
Which name?
But I am NR Enterprise.
You are NR Enterprise.
Yes.
So here.
Your lordship kindly, after the box, your lordship kindly, item number 1, your lordship will find item number 1 meeting of tender evaluation committee under the Birbhum region.
Yes. Yes.
But then, my lord, keep one paragraph. Then, my lord, third, all 4 numbers bidders submitted documents through online, and after verification of some shortfall documents were found in respect of 4 bidders. Hence, tender evaluation committee decided to seek some shortfall documents from all the 4 bidders through online.
Yes.
In respect of 4 number of bidders, namely joyously sales, he was awarded, this firm was awarded with the work. But I'm coming on that. And my lord, my name also transferred, all submitted shortfalls.
Your name is?
My lord, NR Enterprise, number 4.
NR Enterprise, yes.
Then my lord, your lordship kindly, next, they have their decision. After threadbare discussion and verification of shortfall documents, the tender evaluation committee members anonymously declared that 4 number of bidders, namely such and such, such and such, such and such, including mine, were found to be techno-commercial eligible.
Correct.
Then, my lord, a new thing has come. But next page. My lord, thereafter, one of the authority under the same umbrella, who is the regional manager working at Midnapur district, they issued one show cause notice against me for some work. And that was utilized, and despite my technical bid was accepted or found to be sound, my candidature was cancelled.
Where is that?
Your lordship kindly page 126,
yes.
Last paragraph. It starts from top. However, it beginning gather that such and such, such and such. Only they have issued show cause notice against me, and after show cause I replied, and also I started.
However, it has been gathered from the show cause notice dated 5th of February 2026, circulated on that the performance of NR agency is very much poor regarding non-compliance of the awarded work as per the prevailing terms and conditions tender. Also, it has been mentioned that the said agency failed consequently regarding. Yes.
From the last paragraph, they have decided.
Yes.
That in view of the aforesaid matter and to the overcome any unwarranted situation in timely completion of the urgent work, all these things, and they have debarred me from my finance bid.
Disqualified in the ongoing tender process.
Disqualified.
Yes.
This is the reason.
Correct.
And your lordship now, come to annexure P6. But at page 132.
Yes.
But this is a Christian uploaded the paper. But in the first bid list, your lordship kindly come. Number 3, my name transferred.
Yes. Technical bid.
Rejected technical. But once they have decided that my technical bid is sound, and now they have saying that my technical bid is rejected. And my lord, ultimately they selected that Joyce Enterprise. That is number 1. Now, my lord, I am coming to my lord the tender document requirement of the submission of valid tender.
What are the eligibility criteria?
My lord, that is a basic matter. My lord, your lordship kindly turn to page 38.
Yes.
My lord, I'm under clause 6.
Yes.
My lord, A.
Yes.
They must be WBACDCL enlisted agency.
Correct.
Now, my lord, your lordship kindly come to my lord and it's at P5.
No, there is any condition that if any so cause has been issued on another year, you have been debarred.
Nothing.
Is there any condition?
Subsequently, your lordship will find, but the other agency of the same the authority, they have allowed me to participate in the tender process, and my finance bid has been evaluated as a sound finance. My bid was accepted, and I was eligible for finance bid.
Yes, yes.
But the subsequent to that decision of the authority, another authority region at Raiganj or the Jalpaiguri district probably, but they allowed me to participate in the tender process, and my tender was technically sound, and my final bid was required to be decided.
Bhalo.
Now, the same authority started playing the board hot and cold. And my lord, your lordship will kindly come to
Yes, next.
My lord, your lordship kindly come to my lord. Annexure P7, page 133.
Yes.
Got it?
Yes.
But this is the shortfall document submitted by that joystick who has been selected as L1. But what was the requirement? Current enlistment under WBACDCL. But at the last requested document, your lordship got it?
Where is that?
But in the first box, requested shortfall documents, your lordship got it?
Page 133A.
133, only 133. This is the front page of the uploaded document.
Yes, yes. Current enlistment.
Requested shortfall document, and then current enlisted under WBACDCL. Lordship got it right side of that box.
Yes, requested document
shortfall documents.
Yes.
And then at the end, file name, then the requested document description. Lordship got it?
Yes.
Current enlisted under WBACDCL. Your lordship got it?
Correct.
And then my lord, your lordship kindly come to my lord 133A. There your lordship will find that agency was not an enlisted contractor on that particular day because they were asked to appear before the authority for their enlistment.
Yes.
And my lord, your lordship will also find from the page 133D that enlistment was valid up to 5th January 2026. But the last but one line. But your lordship got it, my lord? Validity of enlistment.
Enlistment will be considered from 6th January 23.
And remain valid up to
January 26.
Therefore, the NIT was issued on 16 January. On that particular day, they were not, this firm was not enlisted.
Yes.
And in order to facilitate this particular agency, everything has been done. But under the tender condition,
So
first eligible criteria is
Whether he has placed the certificate of enlistment.
Of that, with the shortfall, it is not there.
Hmm.
With the shortfall, it is not there.
Hmm. Yes.
And my lord, your lordship, my lord, the authority.
Where is your so cause notice?
My lord.
Where is your so cause notice?
My lord. My lord.
Page 127.
On 5th of February. So cause notice was issued on
5th of February.
5th February 2026.
But the fact remains, after that they have allowed, but the same authority allowing me to participate. And my tender, my performance has been considered.
Yes.
And my lord,
So you are the L1?
no, because I have been ousted from the consideration of my finance bid.
Okay. Anything? What is further?
My lord.
That's all.
My lord,
That's all. Yes.
My lord, from this show cause notice, your lordships kindly consider. My lord, prior to that, my lord, work already started. We have given award. If my lords have any, my lord, grievance, naturally your lordship knows the remedy lies before the suit court for damages. Already work started. Now, my lord, kindly see the show cause notice. My lord, he has been.
But before going to the so cause notice, kindly come to the page 36.
One?
Kindly come to the page 36.
36. Yes, my lord.
So technical bid opening date 2/2/2026.
Yes.
Correct. And the so cause notice is 5th of February 2026. How you can act?
Well,
give answer only to that effect.
Well, kindly consider.
Your tender was issued January 21st of January 2026. Opening of the date of the tender of 2/2/2026. Tender was open. And
Well, it was 16. It was 16 January 26.
Yes.
Page 33. 16 January 26. Issued on 16th.
That's why 16 January. Then come to the uploading 21st of January. 36.
Yes.
Uploading 21st of January 2026 and last date of this submission.
No, this date was mentioned. This was mentioning the date and time for Miller.
Correct, I am telling. So you have to go by the table mentioned in the tender document.
Prior to that, your lordships kindly consider show cause notice is Miller 11th February.
Where is the 11th February? 5th of February.
Show cause
notice.
Yes.
You have mentioned 127. This show cause notice?
5th of February.
5th of February.
Well,
and your last date of the tender was of the 5th of the 2nd of February.
Yes.
And where is the condition that if any so cause notice has been issued or he has been.
No, your lordships kindly consider.
You tell me, sir, first you give my answer, then I will hear you. I frame 3 questions, you give answer, then I will hear you. First, you give the answer. Once you are final, the opening date of the tender. Opening date of the tender is the 30th January 2026. 2nd of February 2026. How you consider the so cause notice of 5th of February 2026? This is the first one. Second thing.
Well, this is Miller technical bid opening date.
Correct. Technical bid opening date, what means? Bid open?
Well, on that date, possibly Miller, it was not open. That I will have to take instructions, all these details.
Even not open. But this has not been corrigendum and has been issued.
That I will have to take instructions in details. Your lordships kindly consider this is an urgent work. Your lordships kindly.
Maybe urgent work, but your
for shifting of electrical lines or construction of the bridge, railway bridge.
Maybe.
And my largest.
You cannot go beyond the law. You cannot go beyond the law. How? If, show me the when the registration of the person who has been given the awarded enlistment, when the enlistment was made. Because 5th January 2026, his enlistment was over.
But that I will come to you before your lordships came back to your lordship with all details. Will your lordships kindly give me 7 days time? All
file the report. File the report.
Yes. Everything. What is the necessary? What restraint?
Issue.
Already Miller started.
What can be done? You have not come earlier. You have not come earlier.
Already work started.
Work started. The court cannot go.
Don't take me.
So what can be done?
Yesterday, my junior troubled you.
So what?
When you file the writ petition? When you file the writ petition?
Well, it was filed long back.
When you file the writ petition?
24th January.
Then why you're not mentioned? You're not mentioned. I am taking all the urgent tender matters. You're not mentioned. She has mentioned us yesterday. I have allowed you her. But when the tender order was issued, work order was issued, when the work order was issued.
That I will have to bring all these pictures. So I have taken instructions over telephone, that's it.
Sir, is this in order to facilitate that choice?
No, I will. If I find that all will thing go. I am not that. Yes, work order issued. It will be done by the illegal. I will do all the things in line. If this court find this court find that an affidavit is required to be filed to show the following points. Number one, when the technical bid was open. Number two, when the financial bid was open. Number three, when the private respondent, has made a party.
Yes.
When the private respondent has filed the enlistment certificate. Number three, whether there is any condition in the tender document if any so-called notice issued by the another issued to the petitioner with regard to any work, the tender cannot be accepted. The petitioner, the respondent is directed to produce the total tender process document before this court along with the above query on.
Well, give me at least 2 weeks time because it's a Birbhum, your lordship kindly.
Maybe Birbhum is 2.5 hours.
As your lords.
2.5 hours.
As your lords.
30th March at the top.
Much obliged.
Bring all the documents.
Yes, it can.
But I have submitted
Affidavit service capital.
any steps,
What state?
Give the name.
15.
That item 15. I beg to appear for the petitioner. Malaji practically concluded yesterday, but your lordship pointed out that Hemant Kanodia judgment yesterday. Whereas if I may just place that much and then my senior can begin his submissions. This is Hemant Kanodia versus Bank of India. Malaj will kindly see paragraph 63 onwards. Those are the guidelines which your lordships have often relied upon in so far as declaration of fraud is concerned.
Yes.
Yes. Malaz will kindly just see 64. First, a show cause notice to be issued enumerating the exact offence alleged against the borrower director if any FAR or other document forms the basis of the show cause notice. Then the same is to be served along with the show cause notice. Both the criteria have in fact been satisfied in this case, Malaz, thereafter.
Yes.
Whereas thereafter some other guidelines have been prescribed. Your lordship will also take Malaz paragraph 68 for a moment. Upon such hearing being concluded, a decision shall be taken whether or not to declare the borrower company or its director promoter as fraud perpetrated. Thereafter 69. The very first step has been complied with in the present cases by issuance of show cause notice enumerating the exact fact allegation and serving a copy of the FAR, which forms the basis of the show cause notices. Thus, there is no scope for reason to set aside. However, 70 is perhaps important. The subsequent steps are required to be undergone to give an effective opportunity to the petitioner to rebut allegations made against him and the borrower company. So, subsequent steps is perhaps what I am harping on in this matter, because as we indicated to your lordship yesterday, the addendum to the forensic audit was in fact served upon me post my declaration of fraud.
Okay.
Not by them, and not by them, it was by Union Bank. Maharaj, these are my submissions.
Sir, I will rely upon this judgment. Well, I'm grateful to my learned friend. I will later on I will rely. So there are few dates to be noted.
Yes.
If your lordship takes the writ petition, the date of NPA is sometimes in the July 2022. Date of NPA is July 2022. Thereafter,
where is the order of NPA?
The order of NPA is not here, my lord. I have written in my affidavit opposition. My lord, I shall show the relevant paragraph in my opposition. Thereafter, the show cause notice was issued.
When the NPA was done?
July 2022. I will give the exact.
July 2022.
22.
Yes.
The show cause notice was issued on 7/12/23.
7/12/23.
And the reply to the show cause notice was given by the petitioner, that is at 22nd December 2023.
Yes.
Thereafter we had classified, thereafter we had given a hearing to him, and thereafter, my lord, he has been classified as fraud.
When he has been classified?
My lord, that is on 2nd of March 2024.
2nd March.
That is the subject matter of the writ petition.
Yes.
The challenge to the fraud.
Yes.
Now, Lordship will now take the writ petition, the cause title of the writ petition once.
Yes.
Lord, here Bank of Baroda is the respondent number 1, 2 and 3 also Bank of Baroda, 4 is also the Bank of Baroda. And 5, Raj Gupta, the chartered accountant, has been made a party. Lord, I asked this question to myself, why this person who is no longer associated with the bank has been made a party? But he was an auditor of the bank.
Yes.
Well, interestingly, the bank found that there was something going on between the borrower and this auditor, and thereafter bank decided to remove him. And a second auditor was appointed. The second auditor is not a party to the writ proceedings. Well, admittedly, they had got a copy of the forensic audit report from another bank. This addendum, what my learned friend is relying upon, has not been served by me. Somebody else has served him.
Who?
That they say, this auditor has served him.
No.
We have not served him. We are not in, we do not know who has served him. It is an internal document, the bank is relying upon.
Can I record your submission?
Absolutely. I have stated in my opposition.
You're not given the addendum, and
We have served him the copy of this addendum to him. That is their specific assertion in the writ petition. And the party, the auditor who was representing the bank, the second auditor, he has not been in a party. Now, my lord, may I take your lordship to the show cause notice?
Yes.
The show cause notice is at page 2nd volume. Page 134.
134.
That kindly comes to page 135. Show cause notice. The second volume.
Yes. Page?
Page 135.
Yes.
My lord, these are the grounds on which the show cause notice was issued. It is observed that you have not supported to the investigation for your assignment as it was required, and there are a lot of information which is not provided by you. It is also observed that there are various communication and opportunity already given, and it is observed that you had assured to support, then denied to support, and then again assured to support, and later reply dated such and such stated your inability to submit the information for investigation. On the basis of information submitted, the outcome from the investigation states the below issues due to which the account is getting classified as fraud. It is observed that you have reported such and such. These are all the grounds that have been mentioned. You have been number 2, Roman 2. You have been given the reason for labor unrest.
Yes, these are the
grounds.
Correct.
Now, Lordship will turn to the next page. First, the second, third, your company has taken packaging credit facility based on export orders. However, after multiple reminders, you also have not submitted the information with regard to the export sales to us.
Yes.
The documents which we have been seeking for documents related to export, example, copy of invoices, bill of lading, transport bill. Since the documents related to exports are not submitted, we are not able to understand whether export has been made or not.
Correct.
Now, thereafter, we are unable to provide the same due to accounting software limitations and labor unrest. This was their reply. This was their observation made in some other transaction. Now, thereafter, at the bottom of the page, the same is not verified either by you, either to us or to external agency, that is stock auditor, statutory auditor of bank, forensic auditor, etc. The stock being hypothecated to the bank and the asset of the bank and the same not being available to verification or liquidation raises doubt on actual existence. Now thereafter page 137.
Yes.
Diversion through related party Utkal Galvanizers Limited. Milord, kindly Milord skip this paragraph. Given the seriousness of these issues, we are considering the possibility of reporting your name account to the Reserve Bank of India's fraud in accordance with the master circular. Classification of an account fraud may be serious implications having penal services. Hence, you are given an opportunity to provide reasonable explanation as to why your account should not be reported as fraud. Now, what does he give reply to this show cause notice? Lordship will take page 139.
Yes.
Before delving into the specifics, second paragraph, it is imperative to clarify that our response will be limited to the matters within the purview of the manufacturing division. The financial and the banking aspects related to EPC and auto division fall outside the oversight of the BOB and Axis Consortium. The next paragraph, kindly skip the next paragraph. The Mr. Supreme Company Private Limited has been grappling with a severe liquidity crunch, but primarily due to external factors starting with the COVID-19 induced lockdown such and such, followed by series of real events which was beyond the control. NPA classification July 22, recovery process initiated by BOB at DRT and NCLT followed suit. Lord, he gives the reason. A, B. A number of our clients in Africa who had placed POs with the pre-shipment clause were unable to travel from February onwards to carry out the pre-shipment inspection. C, we could not complete dispatches of domestic and export orders during the last week March, resulting in loss of substantial value of sales during the financial year. Note F, further all-time high sea freight, which went up to almost 5 times increase as compared to average freight up to the year 2019.
See, this court is not going to the facts. Only
Lordship, why I am trying to show your Lordship is, he himself has admitted that there was stringent action, my lord. His factory was under complete lockdown.
That's why I'm telling that the court is not going whether what is the fact or it is.
The show cause notice has
only you have to satisfy. Yes, all the documents which you relied upon in the show cause notice you have served upon, and you are not relying upon the addendum to the forensic.
Addendum, I will show to your Lordship now. I will show to your Lordship what does the the final report says, whether the addendum was relied upon.
Yes.
That I will show to your Lordship.
Because now kindly come to 150.
150, Lordship.
Correct. 150. This is another show cause notice.
No, these are the same.
They are same.
They are same. They have just a duplicate copy has been marked here.
Duplicate.
Not only, my lord, I have to canvass before your Lordship the documents that were relied upon by the bank is mentioned in my show cause notice and also in the final notice of his classification.
Yes.
Now, Lordship takes page 162.
162. Yes.
That is a final notice that is under challenge.
Yes.
Lord, if your Lordship takes in my final notice, it is nowhere mentioned that we had relied upon any addendum. Lord, this addendum, whatever my learned friend is showing, is a document that was prepared by the consortium lead bank. This lead bank, Lord, it is an internal document between the banks. How he came to know, Lord, I do not know. He said that some of the banks have given him. Or the auditor may have given, I do not know. We do not have any instruction to that. If your Lordship takes the entire, I will not trouble your Lordship with the entire final the report of the bank. I will only.
But if it is you are not relying upon the addendum, then you kindly come to the page 136. Kindly come to the page 136. 136. That is table which you are given. Further, it is also you use the manufacturing department funds division table showing that. Got it?
Lordship.
And now you come to 157. This is the addendum. This is with regard to this petitioner only.
This addendum has been supplied by somebody else.
No, whatever it's supplied or not, but whatever the what you have relied upon in the show cause notice, that has been clarified in the addendum. If it is clarified in the addendum, So how you can say you are not supplied and yet this is not the documents?
No,
If it's
your
not
lordship-
like the document, why the addendum with regard to the so-called notice of the petitioner itself?
No, it is this addendum is with regard to, my lord, it is if your lordship takes 155.
Yes.
It is being written to the Bank of Baroda.
Correct.
SVM, this is second auditor is writing to this Bank of Baroda.
Correct.
Now, this is an internal document.
Hmm.
This document should not have been in this writ petition. But it is an internal document with the bank. But I do not know how he got this document. Now, if he wants to say he will only dispute the figures that we have given in the show cause notice. The grounds mentioned in the show cause notice, he cannot deny. He is not denying even. He is saying that yes, there was a factory unrest, labor unrest. We could not open the factory. There was the software problem was there. The server has crashed. If your lordship takes the show cause notice or the final report, what are the grounds in mentioned? How he has siphoned of the money? That is the main issue before your lordship. Now your lordship takes the final notice, my lord, at page 162. For what reason he has been classified as NPA? My lord, if your lordship takes page 163.
Yes.
My lord, if your lordship takes page 3, here there are two columns. One is his classification, my lord, what he has said, and what this is our comment.
Yes.
If your lordship takes the funds remained with the company so as how there can be diversion if fund has not let the company and the related liabilities continue to appear in the balance sheet.
Yes.
Now our comment, bank's comment. Bank has financed only to the manufacturing division, and since the funds of the manufacturing division has been utilized for other division, it will be treated as utilization of fund for the purpose of other than the purpose for which finance was granted. Thereafter, my lord, number 2, next page. The funds have been invested out of the company's own fund derived from the capital reserves over 100 crores. In case of funds have been invested out of the company's own fund, it was resulted in change of capital structure of manufacturing division, which is also not appropriate without the permission of the bank. Thereafter, lordship now takes the next page, 165. We had availed packing credit loan during the such and such for exporting products to various countries. However, we were unable to complete all shipments due to unprecedented increase in the price of steel and various metals like aluminum, zinc, and such and such. The bank's comment is saying, being an established player in this line of the activity, rise in prices of steel and other metal could have been easily anticipated by you, and the required derivative products could have been used to shield against the fluctuating raw material prices. Being an established player, you had significant bargaining power with the suppliers. Thereafter, my lord kindly takes the next 166.
Yes.
He admits there severe labor unrest since 2022, resulting in constant obstruction in operation as well as movement of the materials and dispatches by the agitating employees, and the effect on dispatches led to negative cash flow and operational losses. So if he admits that there was a labor unrest, it was he was a prime, my lord, I should say that instigating the company who was running the business. He should have stopped that labor unrest. He could have.
No, if he has taken the ground of labor unrest, because of that the account is not properly maintained. Correct. He has taken one ground that has to be proved.
My lord,
if you only on the reply and you are telling that you are not satisfied, how it can be?
My lord, these are the grounds that the banks have made.
That's why your bank is telling that yes, they're not satisfied. Not satisfied.
That,
Kindly come
my lord,
to that.
normally, my lord, what happens, my lord, when we go and find the stocks are not there, we see that the stocks have been somewhere else.
Correct. That's why you show, he is telling that with regard to the labor unrest, it cannot be. But you show the contrary document, no, it is not the unrest. This amount
Lord,
has
we
been
could not-
transferred. This amount has been transferred to illegal
Yes,
transaction. Show me
that is the galvanizing, my lord.
Where is your bank in the final report? You have come to the conclusion this is the thing has been done.
Lordship will kindly takes, my lord, the final, my lord, if your lordship takes page 168. This is the main company, the Utkal Galvanizers. Number 2, diversion through your related party, Utkal Galvanizers Limited. Utkal Galvanizers Limited is holding semi-finished stock of substantial value against orders placed on them on the back of export orders which were substantially cancelled.
Correct.
We understand the export orders are generally confirmed or backed by letter of credit, and legal recourse is available in case of any dispute. Lord, if that be so, he could have filed a suit or he could have taken any steps. No document. When the auditor went to the factory, he was denied entry there. We wanted to see his hardware disk. It has crashed.
Okay.
Now, thereafter, 3. The billing for the price variation component is still pending due to an ongoing dispute between us and the customer, Mrs. Gupta Power Infrastructure, to whom the end material was sold. Now, kindly see our comment. You have not shared any legal recourse taken by you against Mrs. Gupta Power Infrastructure Limited for adherence to the contract terms. Further, we understand that not raising debit note will result in evading applicable GST payment and will attract statutory penalties at a later date. These are the grounds, my lord. The ground mainly are the stocks not given for inspection, misrepresentation to get the drawing power, software limitations and labor unrest, and stocks are negligible. These are the main grounds, my lord. And diversion of funds to Utkal Gaivaran, that is also there.
Yes.
Now, my lord, with regard to the addendum that has been showed, if your lordship now takes what my lord has shown, my opposition at page 3, paragraph E. My lord, I have not denied that. In the middle portion, Mrs. SKVM company was instructed to carry out forensic audit in the account for the period first.
Where from your
page 3, I'm sorry,
Affidavit opposition number 4, response number 4.
Yes, lordship.
Yes, page 3.
Page 3, Roman small e. The middle portion, Mrs. SKVM company, has the lordship got it, was instructed to carry out forensic audit in the account for the period 1st April 19 to 31st March 23. The forensic auditor, as per the report dated such and such and addendum dated such and such, pointed out various irregularities and deficiencies in the account. The forensic auditor report pointed out the following. These are all the grounds that are pointed out to your lordship. Now, I have not denied that there was no addendum, but from the final report, it will not appear that we had relied upon this addendum. That is my main submission. I will be relying upon my learned friends' judgment. My lord, I am carrying those judgment. Paragraph 64 that. Now, my lord, may I take your lordship to the application that has been filed by me, which has been served upon my learned friend, but there is no denial to this application. No affidavit has been filed. Why I try to point out to your lordship is,
yes,
my application being CAN 1.
CAN 1 can increase the can improve your case of the affidavit opposition. CAN is only for vacating. Now,
No, that is
court is taking
that is not only the ground for vacating. That is not only the ground for vacating. The vacating is on the ground of suppression of.
Correct. So now the court is taking the full matters.
No, on the ground of suppression. Why suppression? This
not taken the suppression in the affidavit in opposition.
That is there, but I have annexed.
so.
But I have annexed certain documents that has been suppressed in this writ petition.
Where is your CAN?
If your CAN is 1 of 2026, a small, very small application.
CAN is not there.
May I hand a copy to you, lordship?
Yes.
If your lordship takes page 17. Why I am trying to show this orders is
Page 17.
Page 17, lordship.
Yes.
This order has been passed at the behest of Tata Capital Finance Services Limited. If your lordship takes the middle portion under section 95(1).
Yes.
Now, this personal insolvency proceedings has been initiated in the year 3rd April 2024.
Yes.
The writ petition was filed, my lord, sometimes
July 24.
July, my lord. So he
June
was
24.
My lord, he appears, my lord, somebody else, somebody had appeared for the personal guarantor. So he was aware of these proceedings.
Who is the personal guarantor?
You know, this is the Harish Kumar Agarwal, that a writ petition of your lordship.
The petition here.
Yes.
Yes.
The series of orders have been passed and he had been representing all through.
Yes.
Now, Lordship takes page 17 onwards.
Hmm.
Means I have annexed all the orders that were available in the website. Lord, he was being represented
Hmm.
all through.
Correct. What order is passed?
Now, Lordship takes page 24.
24. Yes.
Lord, but page 24, my lord, I do not think it will be required because it is for regard to another guarantor who was there in this company.
Yeah, Rani Agrawal.
Yes.
Rani Agrawal.
He's although my lord, he was a direct guarantor of this company, but he's not required. So this is a final order, my lord, at the page 23.
Yes.
Canara Banks, my lord, my lord, Canara Banks want to intervene in view of the fact there is a separate guarantee with the person.
You are the Bank of Baroda.
Bank of Baroda. My lord, we did not have any knowledge of this. For that reason, my lord, while filing of this affidavit, we did not have that knowledge.
Hmm.
The Canara Bank wants to intervene in view of the fact there is a specific guarantee with the personal guarantor, namely Harish Kumar Agarwal. Accordingly, we direct RP to appear in person on the next date of hearing to obtain instruction to that effect. We record that on 10 December 25, the parties are settling with the bank, and therefore Canara Bank wants to intervene in the matter since Tata Capital will leave them high and dry. Now, this Harish Kumar Agarwal was being represented under the section 95.
Correct.
Now, what section 95 of the IBC says? 95 1. Lordship, can it? '95 and 96. Lord, here even in another proceedings, even an RP was appointed.
Yes, 91. Application by creditor to initiate.
Kindly text 96. The interim moratorium. RP was appointed in this case. Where an application is filed under section 94 and 95, an interim moratorium shall commence on the date of application in relation to all the dates and shall cease to have effect on the date of admission of such application. And during the interim moratorium period, any legal action or proceeding pending in respect of any date shall deem to have been stayed, and the creditors of the debtor shall not initiate any legal action or proceedings in respect of any date.
Yes.
Now, my lord, may I take your lordship to the legal aspect?
So what you want to say from here?
My lord, at the best, this writ petitioner should not have filed, could not have filed this writ petition, my lord, in his personal capacity.
What?
The RP should have been appointed here because RP has already been appointed in his
So RP has been appointed, you are admitting that.
lordship.
Correct. So how you can default the pass an order for default willful default against the petitioner if the petition is under the IRP?
If the petitioner, my lord, if a lordship now takes,
You are taking this, so your order has gone. So
If
you
you
could have been you could have been issued the notice to the IRP.
my lord, this willful defaulter is with regard to the circular issued by Reserve Bank of India.
So you cannot take the two grounds.
No, my lord.
If you take the grounds,
He's only answering the legal point, that it's separate. It has nothing to do with corporate debt restructuring. This has penal measure. Therefore, 95. Actually, the moratorium operates in my favor.
correct.
It
That
doesn't prevent me from coming to court.
He does not prevent him, but he should have been represented through an RP. That is my whole submission.
I can't be.
if a person has been declared willful defaulter, you have not declared the willful defaulter to the RP.
No, my lord. He will, supposing, I give an example to your lordship. Suppose
Where is the letter from you that to the RP that he has been declared the willful defaulter?
No, he has not. We have not.
You have not then?
Supposing, my lord, a company goes into liquidation.
Correct.
The company will be represented now, either in earlier cases it was through the official liquidator. Now it is through an RP. So he must be represented by the RP in this writ petition also. That is my submission.
Okay, I will take your submission. Okay, he cannot file. He could file by through RP. So what would be effect of the order passed by you?
My lord, this writ petition, my lord, this
because what you are harping upon the order dated. What is the date of the order? 5th of January 2026. Correct. So what would effect of the willful defaulter?
Because this is with regard to the Reserve Bank of India guidelines that has been directed to classify him as a fraud, the account to be a fraud.
If suppose, before you declared as a fraud, RP has been appointed and all resolution professional liquidation has been done. So what would happen?
For that reason, my lord, we have not taken any action against the company till today. Company has been, my lord, under the NCLT proceedings. That is going on. Company is not before your lordship. Only the personal guarantor, he is before your lordship.
Okay. Next. How much time will take?
Only, my lord, I will cite only 2 judgments, my lord. My lord, 2025 SCC online, Rajasthan 6188. Note paragraph 11.
SCC online, Rajasthan.
SCC on 2025 SCC online, Rajasthan 6188.
6188.
Lordship. Lord, paragraph 11, 11.1 and 13. Lord, on the proposition that the parties to come with clean hands. Lord, here the Supreme Court judgment is also quoted. Lord, I am just placing paragraph 11. The High Court's function not only as a court of law, but also as a court of equity. Therefore, anyone seeking equitable relief under Article 226 of the Constitution is obligated to present all relevant facts before the court fully and truthfully. The foremost condition for invoking the extraordinary jurisdiction of a constitutional court is that the petitioner must approach the court with clean hands. Concealment or falsehood disqualifies a party not only from seeking.
This is settled law by the Supreme Court.
Lordship,
Why you are going to the Rajasthan High Court?
Well, there are Supreme Court judgment is also there, in the quoted.
That is settled law.
Lordship. And my lord, I would also cite one judgment that it is 2025 SCC online, Supreme Court, page 374. 374. Paragraph 8, 9, 10, 11 and 14.
Yes.
My lord, here it says that the High Court should not interfere while PRP is under process. My lord, paragraph 9. The adjudicating authority by order dated such and such has followed the procedure envisaged under section 95 to 100 of the Insolvency and Bankruptcy Code and has relied upon the aforesaid principles of in Jurajka. It is specifically observed the respondent number one's obligation regarding limitation, waiver and guarantee will be considered once the resolution professional submits his report. This is correct approach as the appointment of a resolution professional at the very threshold is statutorily mandated under section 97 of the IBC. Held by the Jurajka. The adjudicating authority does not adjudicate at any point of stage and need not be decide the jurisdictional questions regarding existence of the debt before appointing the resolution professional. Kindly may not skip thereafter paragraph 10. In the light of this statutory scheme, which has been followed by the adjudicating authority, we are of the view that High Court incorrectly exercised the risk jurisdiction. First, it precluded the statutory mechanism and procedure on the IBC from taking its course, and second, to do so, the High Court arrived at a finding regarding the existence of the debt, which is a mixed question of law and fact, that is within the domain of the adjudicating authority under section 100 of the IBC. It is well settled that the statutory tribunals are constituted to adjudicate and determine certain questions of law and fact. The High Courts do not substitute themselves as a decision-making authority while exercising judicial review.
How it is applicable to you?
Because
sir?
section 95 is applicable to him.
No, that is okay.
Now, my lord, the last decision what my learned friend has cited today,
yes,
I would rely upon paragraph 64 once. Lordship.
Yes. Yes. No, that is correct. That's why my telling only they have to show before this court because this court cannot go into the merit of the matter. That is the authority has to decide, your bank has to decide, the review authority, appellate, whatever it may be. This court has to see whether the process has been followed.
What is alternative partem, whether that has been given. Hearing was afforded to him.
That's why
we have not.
That's why they have made it 2 grounds with regard to the so-cause. So-cause now they are telling that they are admitting that the so-cause was received by them from the other bank Now, second is the
The
addendum.
show cause we had issued.
No,
the-
with regard to the forensic. Forensic. And with regard to the addendum, you are telling that the addendum has not been relied upon.
Yes, that is right.
Addendum, you are admitting the addendum, but you are telling that the addendum is not relied upon while passing the final order.
Lordship,
This is the
this is the only limit. I'm grateful.
I just respond in 2 minutes. Your Lordship will bear.
yes, not more than that.
Not more, my lord. The two issues, firstly on just facts, because my learned senior friend has said something which is possibly contrary to the record. But page 143, your Lordship will once have a look at. This is my, but your Lordship has also pointed it out to him today in the course of this hearing. 143 at the bottom, this is my reply. We have found that the audited stock figure in your letter are not matching with the audited balance sheet. Total stock figure as per audited balance sheet as on 31st, and then 21 and 22 were as follows. Further, it seems that there's a typographical error. The figure for so and so actually relates to financial year 2021, 2022 respectively, 21-22. We have not yet got audited the balance sheet for 22-23. And we've said after, the forensic auditor has highlighted difference in trade payables reported in the stock statement vis-a-vis the audited financial statements. So if it's not audited in respect of a particular financial year, then how could you add that in the show cause notice? This prompted the addendum which I'll show. Well, if your Lordship looks at 156. Uh, 155, I'm sorry, my lord, 155. This I'll keep within the 2 minutes, I promise. 155, on the basis of the available information, we had submitted the forensic audit report for the account of the petitioner. However, please mark this, there are few additional information shared by Union, Tamil Nadu, Bank of Baroda. Taking the same into consideration, the addendum to our original report is considered as followed. Now, your Lordship will turn over to 156.
Yes.
Due explanation was sought by the SIT committee of Bank of Baroda, and on the basis of the same, bank has shared narrations of the current account and requested, these 3 words are the most important, requested for the opinion post submission and discussion of the same. The analysis of the same gives an inference that the funds received and so on, so then it goes into the merits. But the last sentence your Lordship will see is towards payment to Vishwanath projects. The total payment to Vishwanath during the period 26 September 22 to 21st December 23 is so and so. So when I point out that you've relied on audited balance sheets, but for that financial year there is no audit, then how are you relying? This information gets shared. Based on this, they seek opinion. Then for that financial year, certain other particulars are considered. Then 157, your Lordship will please see. There is an inventory of so and so. However, there is a typographical error at point 2.1.7 on page 41 in our original report submitted to the consortium. So I highlight, they run back, get this whole thing again changed, and then they pass this order saying difference between so and so. And the last paragraph 5, considering the additional information submitted, the conclusion of our report submitted on 5th December is restated as follows. Our conclusion is on the basis of the information made available and logical analysis of the same, Master Circular of Fraud. Which is my learned senior friend, in his fairness, admits in paragraphs of his affidavit that he has relied on the addendum to declare me as a fraud.
Yes.
And all of that, my lord, is affirmed as true from records, not knowledge.
Yes.
I had shown those two paragraphs, my lord, yesterday, your lordship.
Okay.
Paragraph 3E and one at page 6.
Yes.
Now, my lord, with regard to the point of locus that he's taken, Lord, page 137, one thing I'll just show. This is part of the show cause notice itself.
Yes.
137, last sentence, if your lordship could see. Classification of an account as fraud may have serious implications having penal and civil consequences. CBI written about it?
Yes. Yes, then?
So, my lord, this 95, you will give me 1 minute, my lord. Your lordship is aware that under the fraud circular, you have to report it to CBI. 95 bar. Firstly, the moratorium exists in my favor. Secondly, the bar is in respect of corporate debt restructuring. The query that your lordship had put to him, the moment it partakes the character of any penal action, it has to be me. And I don't say that. You know, today we've taken the temerity of handing up that CBI writ petition. Please have a look at it once.
CBI writ petition.
They have, yesterday we had given it, you know. To show that they were taking steps contrary to the impugned order.
Which one?
Kalo clip. That's not the best way to identify records, my lord. I'll just indicate what is there. You know, when the bank files against me, they don't do it through the IRP or the RP. They name me only. Serial numbers, parties number 6 to 9.
You are not understanding or coming from there. That's why I'm telling you, search it out. You are more intelligent. When I am searching, you are disturbing here. What you have supplied?
But there was an interim order restraining them from taking coercive steps. Despite that, they had gone ahead and filed a writ petition against me and these petitioners that we've made the complaint over to the CBI. The CBI is not taking any steps, right? Yes. Police inaction writ that they had filed.
That is not been supplied.
It doesn't matter, my lord. Your lordship will just once for a minute make a note of it if you require, that in that writ petition against the CBI, the petitioners were added and not the IRP or RP. Why? Because it's only in matters of corporate debt restructuring that my locus is removed. But when it comes to penal measures, like a 138, the IRP or the RP will not go and contest it. Not just because he's taken the point, I'll cite for the sake of completeness, I'll cite that one decision. Correct, অন্যটা এটা দাও এটা MMDR এটা just 1 second, bro.
You're not coming with all documents. You're with all the log. You're searching the documents.
No, I'm just citing this decision.
What are the documents?
Yes, 2025.
But half an hour you're searching the document with the all your juniors.
Just the decision. He's taken that point today. Just that much. 2025 6 Supreme Court cases 781. Your lordship will just give paragraph 22 and 23 a cursory glance. What is the legislative I'm sorry.
Yes.
What is the legislative intent behind 94, 95? I'm not troubling your lordship with it. 24, please have a look at. 23 and 24. That when there is a penal action, it has no bearing on a 95 or a 96 proceeding. So IRP or RP doesn't come in. Here, admittedly, this has penal action. My learned friend also naturally admits to that.
Oh, he is telling that you have appeared before the NCLT, you had the knowledge, but RP has been appointed. Why you have filed the writ application? This writ application.
Basically, the issue of locus that IRP or RP should come in. That's why I'm showing, if there's a penal action, I am not required to. And the two decisions he cited, I'll just distinguish it for like in 30 seconds. The first decision is paragraph 7.2. Your Lordship will make a note of. There was a separate civil suit that was pending, which was suppressed from the court.
Civil suit is pending.
That's the judgment he cited, the Rajasthan decision. The suppression was paragraph 7.2.
Yes, he is telling that the suppression he has taken with regard to the NCLT proceeding.
NCLT proceeding, that locus I should have come and shown it.
Yes.
And the other one, my lord, that he cited of 2025, the Bank of Baroda versus Farooq Ali Khan. There, my lord, there was a writ petition that was moved to interdict the 95 proceeding.
Correct.
Their court held that there is a statutory mechanism go before the NCLT. Here we've not done that. This action, A, has penal consequences. B, it has nothing to do with my corporate debt restructuring or my debt restructuring as a guarantor.
Yes.
This is an independent action that flows from a RBI circular, which I am assailing.
Yes.
Well, these are my respectful submissions.
Okay.
That's all? Yes,
Yes. Hearing concluded, CAV.
Good. That extra second we took, we were looking for that judgment. But two, that. Very great.
Call the investment. Yes.
Malad, I just saying leave to file a supplementary affidavit giving the details of the.
So the copy.
I am just. I have given the details, Malad. All documents which are available, I have given it. Malad, just your lordships kindly come. Two paragraphs are very important here. The page 2 kindly come. Paragraph 3, the registration certificate and the PSO license with regard to the trunk tag offered by the petitioner under the ATS framework are transferred in his name on 14 January 2026 and 23rd February 2026 respectively. Annexure I am coming. Next, that will be the gist of the things. Now, paragraph 4. Timeline of the transfer of registration certificate and the PSO license of the trucks offered by the petitioner under one truck. First, second, third, all formalities have been made. So far, number 4 is concerned, PSO license is under process. We have given it details.
Okay.
Now, your lordships can see the documents from page 5. Then 6 vehicles particulars. Then page 7, this PSO license. 23rd February 2026. Before issuance of the show cause notice. And also, my lord, kindly see this PSO license. Then the next one, page 8. Again, is a certificate, vehicle particulars. Then the PSO license. This is 19 February 2026, page 10. Then, my lord, page 11. Then, my lord, page 12, vehicles particulars. Then, page 13, PSO license, 19 February 2026. Then, my lord, page 14, and there also transfer date is also mentioned. Page 14, then page 15 and page 16. This is a PSO license, 25th February 2026. Transfer dated 8 January 2018. Then we'll have page 17. But all are, it is there. All that documents are there, excepting PSO license of the
one vehicle.
Oh yes, number 4.
Yes.
And I was submitted around 5th March. You should have, the show cause, why it has not been done. Then the reply would have been there, not the penalty and etc. Already yesterday I have submitted.
Yes. Yes, sir. What is our instruction?
My lord, I will place that corrigendum once, my lord. Page 145.
145. Yes.
In case the bidder fails to submit the required documents with change of name, etc., within 4 months of issuance of LOI, suitable penal action shall be taken, which may include. These are not the only penal actions which can be taken. These are, which has been mentioned herein, are inclusive. Include EMD forfeiture, caution money forfeiture, termination of order of such TTs, and blacklisting of such TTs. Under no circumstances will the above mentioned timeline be extended. In such cases, the contracting corporation reserves the right and shall be at liberty to induct TTs as per the methodology mentioned in the tender to fulfill the shortfall arising thereof. So my submission is, my lord, so far as suspension is concerned, it is already included. The part of suspension is already included in this particular clause, and it also mentions that in no occasion this timeline will be extended. There has an affidavit to this effect had also been filed during the bid documents. The similar condition is there in the letter of appointment which I have shown to your losses yesterday, and as well as the work order. Now today, this has not been complied with. The timeline got expired in December. Even during the next 2 months, it was not complied with. Thereafter, in March, the SOCOS notice was issued. There was no application during the subsisting period for seeking for an extension. Now today, the SOCOS notice has been issued, seeking for an explanation.
But SOCOS notice is issued with this suspension. That you said. How you can satisfy that?
But for that, I have shown that this particular clause.
Yes, kindly come to that clause again. You read it. Yes. You can take a suitable penal action. So penal action, before the penal action, there is a opportunity of hearing. Opportunity of hearing is a SOCOS notice. SOCOS notice cannot say that with the penal. Suspension is also the penalty. Can it be? That is the only question.
And two other issues, your losses knows that it is a premature state because of SOCOS proceedings. The decision, final decision.
That's why I told you. Because see, you have issued the SOCOS notice with the suspension order, and he has to submit the report. Now, in the meantime, one vehicle has got registered and one is under process. So he will submit the report and take appropriate.
Yeah, he has also already submitted a reply. The reply has already been annexed.
Submit another reply.
You will submit another reply with all documents, and you consider within period of taking into consideration the vehicle already been transferred in his name and one is under transfer.
But in that case, I will humbly suggest, subject to your losses consideration, that your losses may stay that portion of this SOCOS so far as the suspension is concerned till the final decision is taken in the SOCOS proceedings and can dispose of.
Very nice. I have no objection. Just I 1 or 2, 3. I point. He is saying, my lord, the license is a statutory license. That is compulsory. If that is their stand, there is no question of giving that you give it within the 4 months. Therefore, this is contradictory.
Correct.
And second, my lord, no one cannot do it if there's compulsorily statutory requirement. Correct. Second is that you have allowed up to 5th March. Without that, therefore, it is also not compulsory. 5th March, SOCOS already I have argued that. What I am submitting to your lordships, that now the scenario has been changed by this time. Now, kindly, my lord, this SOCOS notice be set aside. Let them give the liberty to issue SOCOS notice.
No, my lord, SOCOS notice has.
SOCOS notice, kindly see, appreciate this. This SOCOS notice, I have to give again the reply, na? Giving all that details, I have to give reply.
That your losses may permit to give supplementary reply.
No, what I propose to do, I will stay the suspension.
Correct.
I will stay the suspension. I will give a liberty to file a supplementary reply to the authority. And take the decision, file a supplementary affidavit in this court with the final order.
My lord.
That will be better.
Very nice. No problem. I have no problem.
Your losses is keeping the writ petition pending.
Pending. I am staying the suspension order, giving the liberty to file the supplementary affidavit, supplementary reply, and you take the decision and file the supplementary reply, supplementary affidavit before this court, enclosing the reply and the disposed of. If you want the disposal, then I will dispose of.
Your losses may disposed of, directing the authorities within a time frame to take
How
final
much time you will take the taking decision?
So fix a time, any 2 weeks.
My lord, I have no objection. My lord, only one request I am just request. My lord, if any punitive decision is taken, that will not be given effect for another 7 days.
No.
But
But today, even it's a premature stage.
No.
That's
That's why I wanted to keep pending.
Just kindly keep it pending then.
That's why I want to keep pending here, so the future complications.
I have
will not
future
happen.
complication.
Because this court is of the view that once a writ has been come, that has to be finished.
Finally decided.
Finally.
Everything is.
No decision is challenged before your losses. Only the so-called notice has been challenged. Decision is yet to be taken. And so far as the violation is concerned, my lord, it is apparent from the tender documents, the letter of allotment, the terms. There cannot be any question of.
I am my lord, with great respect to my learned friend, the mode of submission itself, I can take it that as per instruction of his client, it is submitting. If that is so, my lord, then already he has fixed his mind. Therefore, I need a my lord, the protection.
Because earlier the TTs were plying because TTs had the RC and the peso, but it was in name of somebody else. This is only a question of transfer.
See, that's what I'm telling you. In the tender document, you are accepting that you only to show that you have a sufficient numbers of the vehicles, either by in own name or through the agreement or any document. But the condition that after the award is given to you, you have to change the vehicle in your name with all documents. This is the condition. Correct. And you have given the prescribed time of 4 months, which has to be completed. So it has not been completed. You have a so-called notice. In the meantime, it has been completed. Whether the panel can continue or not continue, you have to take a decision. But you cannot, till the decision, you cannot direct the petitioner to stop your work, suspending all the things, because that vehicle is already valid, having a valid document. Only the name is not changed. It is not that the vehicle is not having the valid document, or the vehicle is of the has been taken from the stolen vehicle or whatever it is. It's not your case. So that's if you are taking a decision against the petitioner, then opportunity 1 week time may be given. He can challenge it.
Yes.
Tell me.
বাবা তুই এত এরকম করছিস কেন?
Order of the court.
না আর্গুমেন্ট করলে এরকম হয়।
In terms of the tender notice, the petitioner has yes. The petitioner has participated for bulk LPG transportation contract by road for the state of West Bengal. As per the terms and conditions, as per the corrigendum, as per the corrigendum issued by the authorities, it is mentioned that in case the bidder fails to submit the required documents with change of name, etc., within 4 months of issue of LOI, suitable penal action will be taken, which may include EMD forfeiture, caution money forfeiture, termination of order of such TTS, TT capital small s, and blacklisting of such TTS. Under no circumstances will be about mentioned timeline be extended, full stop. Such cases, the contracting corporation reserves the right and shall be at liberty to induct TTs as per the methodology mentioned in the tender to fulfill this shortfall arising there. Full stop. It is the allegation upon the petitioner that two trucks
Petitioner number 1 is 1 truck, my lord. Petitioner number 2 is 4 trucks. 3 of them have been complied with all the formalities.
No, 3 trucks were not having the not changed the registration when the so-called notice was issued. 4 trucks. 4 trucks. Full stop. Petitioner has not full stop. Upon the petitioners that 4 trucks, the transfer of the name of 4 trucks has not been carried out by the petitioner within the stipulated period of time as mentioned in the corrigendum of the tender document. Accordingly, on 5th of March 2026, the respondent authorities have issued the so-called notice informing that as per the condition, transfer of trucks documents within bracket registered certificate and PESO license, PESO, license within bracket close, in the name of the purchaser was supposed to be completed within 4 months of issuance of the law, but the petitioner has not done so. Accordingly, the TTS have been placed under suspension with immediate effect, and the petition is directed to submit the reply to the so-called notice within 7 days from the date of receipt of the notice. Full stop. The petitioner has submitted the so-called reply, and in the meantime, out of the 4 vehicles,
there are altogether 5 vehicles.
Yes,
5 vehicles.
Total 5, my lord. Petitioner number 1, 1 vehicle, and petitioner number 2, 4 vehicles.
That has not been changed. Changed.
No. Changed is, my lord.
What is the allegation?
Yes, not 5. Total number of vehicles are 5, which has not been changed.
5 na? Full stop. Petitioner has filed the supplementary affidavit. But in the supplementary affidavit, it disclosed the 4 only.
My lord, paragraph number 3, it is mentioned about the petitioner number 1, my lord.
So file the supplementary affidavit stating that the one of the truck of the petitioner number 1, the name and one of the truck with respect to the petitioner number 1 has already been transferred in the name of the petitioner on 14th of January 2026 and 23rd of February 2026. As regard the vehicle of the petition number 2, 3 vehicles have been transferred in the name of the petitioner, and PESO license has also been issued. But with regard to the 1 vehicle, the registration has been transferred, but with regard to the PESO license is under process. Full stop. Learned counsel appearing for the petition submit that the respondent authorities have issued the so-called notice by imposing the penalty of the suspension which is not in accordance with law. Full stop. The authority ought to have given the so-called notice by giving an opportunity of hearing to the petitioner to transfer the name and PESO license. But instead of that, the respondent have issued the license, issued the so-called notice by suspending the vehicles of the petitioner. And as such, being agreed with the said act, the petitioner has filed the present writ application. Per contra, an advocate appearing for the authorities submit that as per the corrigendum, submit that at the time of issuance of the LOI, the petitioner has submitted an affidavit undertaking stating that the petitioner will take appropriate steps for change the name and other formalities within 4 months of issuance of the LOI. But the petitioner has neither transferred the ownership of the vehicle nor taken any step with regard to the PESO license. Even the petitioner has not made any representation for extension of time for transfer of the name as well as the PESO license. Accordingly, the authorities have no other alternative but to issue the so-called notice by suspending the petitioner. Full stop. The petitioner, the learned advocate appearing for the respondents, have relied upon the above mentioned penalty made clause and submit that in the said clause itself provides the penal and accordingly before passing any further penalty upon the petitioner, the authorities was of the view that the petitioner should be suspended accordingly the license of the accordingly the in the so-called notice the work order of the petitioner with respect of the vehicles which has not been transferred has been suspended. Had the learned counsel for the respective parties produced the materials on record. Admittedly, there is a clause that within 4 months the petitioner has to transfer the ownership as well as the PESO license within 4 months. The petitioner has not transferred, but the petitioner has made an application for transfer of the transfer of the ownership as well as the PESO license, but it was pending before the authorities. Now the petitioner has filed the supplementary affidavit wherein it is found that out of the 5 vehicles, 4 vehicles have been, with respect of the 4 vehicles, the ownership as well as the PESO license already been transferred. And with regard to 1 license, only the PESO license is required to be transferred, which is under process. In view of the above, this court did not find any, this court find that no purpose should be served by keeping the writ petition pending. Accordingly, the writ petition is disposed of by staying the operation of the so-called notice with regard to the suspension of the petitioner and directing the respondent authorities to petitioner, full stop. The petitioner is given liberty, though the petitioner already filed the representation, already filed the reply to the so-called notice, comma, the petitioner is given further liberty to file a supplementary reply to the so-called notice by disclosing the documents to show, by showing that the name ownership of the 5 vehicles have been transferred along with the PESO license, and with regard to the 1 vehicle, the PESO license is under consideration. If any representation within a week from date, and if any further representation is made by the petitioner, comma, the authorities have considered the same and will pass the appropriate order within a period of 2 weeks. Within a period of 2 weeks from the date of receipt of the supplementary reply.
And conclude the so-called proceedings.
And to pass appropriate order by concluding the to pass appropriate order with respect to the so-called notice issued by the respondent authorities. It is made clear that in case if the authorities are against and the authorities is going to pass an in case the order, if any, pass against the petitioner, comma, the order shall not be given effect for 1 week from the date of the order.
Your lordships may also indicate that it's a peculiar facts and circumstances because it may not be precedents.
Considering the peculiar facts and last one. Considering the peculiar facts and circumstances of the case, this court is of the view that if the petitioner, if the authorities found that if the authorities pass any order against the petitioner, comma, the same shall not give an effect to for a period of 1 week from the date of the order. WP is disposed of. Yes, next.
17 to 20.
Yeah.
Well, in item number 19, I am appearing for the bank respondent number 1 and 2.
Okay. 17, who is appearing?
I appear for the petitioner in all the matters. Kindly seize your lordship's order of 10th of March 2026.
10th March. Courts find the respondent paid for the instruction according time for bank question for taking next. Yes, by reporting the arbeit or law. Yes.
This is WPA 2 in 978 that order was passed. One is WPA 26107 where Union Bank of India is a respondent. 26107.
Yes, 26107 Union Bank.
Here, my lord,
in terms of the instructions, my lord, we had invited your lordship's kind attention to the fact that, my lord, in the impugned order, these mentions the account of the borrower company have been specified as false, and this will be accordingly reported to the RBI and also to the law enforcement agency for further investigation. This court finds the respondent have prayed for time to take instructions accordingly, such and such. And insofar as the other matter is concerned, my lord, the bank was supposed to respond with instructions as to what they propose to do. My lord, just for your lordship's very kind recapitulation, my lord, here your lordship is looking at a forensic audit report, my lord, which was conducted without the person, not the writ petitioner before your lordship, my lord, having participated thereat, because he was in custody. And, my lord, the company was put into liquidation in terms of an NCLT order. The official liquidator had taken away all the documents. In the fraud classification, my lord, in the forensic audit, my lord, innumerable references are there indicating that, my lord, no documents what the value of its paper, my lord, was forthcoming from the end, and that ultimately, my lord, the conclusion reached. And thereafter, my lord, the endeavor to classify this account as fraud by resorting to this forensic audit was, my lord, assailed before your lordship. Now, my lord, SBI is today, my lord, before your lordship, my lord, SBI was supposed to. SBI is 17.
SBI is 18. Union Bank is 17. Daily I get a brief for a bank, that's why I want to.
My friend will always, my lord, cut. My lord.
He is telling that you are arguing, that's why he is silent.
Yes. Please see.
Not disturbing you.
Please see, my lord, the Union Bank of India's matter. My lord, in the
Union Bank of 26107.
Yes.
Yes, please.
My lord, please see Union Bank of India's writ petition.
Yes.
My lord, the
Where is the
communication.
Where is the show cause?
My lord, show cause is, my lord, the last page. My lord, kindly comes to the last. Union of Bank of India. My lord, by way of a supplementary affidavit in connection with Union Bank of India, my lord, I had invited your lordship's kind attention to page 14 of the supplementary affidavit.
Yes, supplementary affidavit kota hai.
My lord, insofar as Union Bank, my lord, I think I had served, my lord, on my learned friends. 26107.
Filed. We have been served with it, that is why time was taken on the last occasion.
আমাকে মারতে এসছিস কেটি মেরেই তো এসছি এখন তো মারি খাচ্ছি তোর কাছে
Yes.
My lord very kindly got it. My lord kindly sees page 14.
Page
14.
Yes.
Now, my lord, page 14 would show. My lord, this is the communication of 21st of February 2026. My lord, it says order on classification of Pincon Spirits Limited and its directors as fraud under the RBI master directions. Now, my lord, after narrating the facts, my lord kindly sees the last paragraph at page 17.
Yes.
That in view thereof, the competent authority has concluded that there exists elements of fraud in the activities operation of the borrower company and its directors who are responsible for its activities, affairs, and operations as mentioned in the SCN dated show cause notice dated 13th October 2025 and directed the undersigned to convey their decision to the borrower company. That it is therefore hereby conveyed to the borrower company and directors above named that the account of borrower company, measures Pincon and its directors, Monoranjan Rai, who are in charge and responsible for the affairs at the relevant time, have been classified as fraud This will be accordingly reported to the RBI and also to the law enforcement agency for further investigation. Now, my lord, insofar as Union Bank of India is concerned, this is the communication which we have appended by way of the supplementary affidavit. Now, my lord, I respectfully submit to your lordship, in the other banks, there are 4 writ petitions apparently. The 2 were taken up for consideration, SBI and Union Bank. In SBI, your lordship will not find this. In SBI, your lordship will get the entire forensic audit report. Now, insofar as the show cause notice here, please come to page 63.
So what is your grievance now?
Now, my grievance is, this classification of fraud on the basis of a forensic audit conducted, without resorting to any documents and papers. This classification, this conclusion.
Where is the so cause?
Yes, page 63 of the writ petition. Page 63. Now, kindly comes to page 63. Yes.
Yes. I think one appellate side rule is to be amended. One group has to be created for this, for the bank and fraud cases.
Two assignments should be given to 2 benches, at least.
Now, my lord, please see the show cause. I was inviting your lordship's kind attention to the show cause. Now, my lord, please see show cause notice, examination of irregular anomalies, allegations, commissions, etc. of PINCON spirits from the possible angle of fraud. My lord, this is a 4-page show cause. And my lord, please see.
Where is the so cause that they have applied for? They have relied upon the forensic and all these things. What are the documents?
64, kindly sees.
64.
Under the table.
Yes.
As certain irregularities were noticed in the caption account, lead bank of the consortium, namely State Bank, caused a forensic audit in the account in order to ascertain more facts on such irregularities. The forensic auditor submitted report dated this, copy enclosed for your reference, observing inter alia the following irregularities. So, they resort to the forensic audit, and the forensic audit, here the lead banker was State Bank of India.
Yes.
There was a consortium of banks. Lead banker was State Bank of India. The forensic audit, that was conducted, the report that was prepared, insofar as State Bank of India is concerned, apparently was used here, so as to, prima facie, at that stage, classify my accounts or classify me as a fraud. Please see. Please see. PINCON spirits management did not cooperate with auditors and did not provide books of accounts. I put this question to myself, which I had, my learned senior Mr. Kaur had pointed it out to your lordship. We had indicated it fairly. These documents were not with us. Admittedly, these documents are in the custody of the official liquidator. Apart from that, we had in the forensic audit, innumerable places they say that, these documents were not forthcoming. If the documents were not forthcoming, by no stretch of imagination, any conclusion regarding my complicity could have been reached. They had seized these documents. The entire set of documents are.
Where is the reply?
Yes. Page 67.
Yes.
I refer to the email, the show cause notice mentioned about enclosure submissions of a report from the forensic audit. However, the same is not found enclosed. This is one aspect. The forensic audit report apparently finds place in the SBI's matter.
Yes.
Insofar as Union Bank of India,
where is the IBC? Where is the consortium that this RPS was appointed? The company is in liquidation.
Page 79.
No, you are not taken the ground in this reply. So-cause reply. Have you taken the ground in the so-cause reply?
I have said it is sub judice, number one. at page 71. And Milord, I would like to emphasize, Milord, page 71, first paragraph, that the consortium borrowed account of PSL, Pincon Spirits Limited, turned LPA with the SBI-led consortium is only becoming a technical default created by an action of state government, etc. And Milord, previous paragraph, Milord, please see, I'm sorry, Milord, I'm grateful to Mr. Mukherjee, Milord. Please come to page 69. Page 70, I'm sorry.
Yes.
I would like to state as under, during my custody period in January, I had communicated with all consortium member banks, giving my humble submissions, clarifications, viewpoints, which were duly received by all member banks, including your bank. A copy of my such and such may please be perused.
Yes.
I had communicated with Bank of India, one of my letter clarifying various issues. I have submitted OTS proposal with State Bank, etc. And Milord, an impediment application has also been filed with the Honorable Supreme Court, being civil appeal number such and such. Well, this is what we have stated in the response.
Yes.
And Milord, this bank was also a part of the COC. It cannot be, Milord, the lead bank was State Bank. And Milord, Union Bank, Bank of Baroda, and Milord, the other bank, which is HDFC. Milord, all these three banks were a part of the COC, and they could not have been in the dark. And Milord, please see the order of the NCLT. It begins at page 79. Milord, please come to page 86 for a moment. Please see wide order dated 19th July. This application was admitted, and Milord, one interim resolution professional was appointed subsequently as page 70, 86.
Yes.
Milord, I am reading paragraph 1, last 5 lines.
Yes. Partha Kamal Sen is a interim subsequently as per the order replaced by Vinay Kumar Singhani. What was the final order?
Milord, ultimately, Milord, this company went into liquidation. There is no dispute regarding this.
Yes.
Page 99 kindly. 98 bottom, 99 top.
Director issue public announcement. Yes.
In the result, the application by ordering liquidation of the corporate debtor, namely such and such, in the category of this, and Milord, page 99 top.
Yes, yes. Got it. Yes.
In terms of regulation of the insolvency process, the registry is directed to communicate this order. The order of moratorium shall cease to have any effect, and a fresh moratorium under this act will be published. And the liquidator is directed to proceed with the process of liquidation. F. This is the order.
Yes.
But they still haven't received the documents. They are still proceeding against us. And Milord, then Milord, we had furnished we had filed an application before the liquidator. The liquidator, Milord, had filed an application, Milord, seeking release of the documents from the DEO and assets from the respective statutory authorities. That was, despite direction, Milord, those documents are not yet available. Now that is at page 103.
Yes.
This application was at the instance of the liquidator for deattaching the assets of the corporate debtor. And Milord, please see the ultimate conclusion part. Order. Order is at page, Milord, 112.
Economic affairs government.
is hereby directed to deattach all the properties to restore possession to the liquidator. So, my lord, this entire thing, all documents, all papers, all correspondences lay with the liquidator, or if at all, my lord, the DEO.
Yes. That's all. Any further?
Now, my lord, this is insofar as Union of Bank of India, and apropos my reply to the show cause, which is not there in the other two matters, subject to correction by Mr. Mukherjee and my learned friends. They have already classified the account as fraud and have also indicated that they are going to inform the respective statutory authorities, including the investigating agencies. Now, that portion of the order, at that stage, we had drawn your lordship's very gracious attention, and ultimately, the order that was passed on 10th was passed. Union of Bank of India, is to make.
Yes, Mr. Thakur. What is your answer?
Lord, two dates are important, Malad. This gentleman, petitioner, was released from custody on 22nd September 2023. He says in his writ petition that I was released fairly recently. He does not give the date. I have got this date from the orders on the website of our court. Now, if he's arrested in some other proceeding, I don't know.
He was in custody, for my learned friends, information, 16th of October. He was in custody from 2nd November 17 to 16th October 24.
16th October?
24.
Very. 16th October 24. Now, my lord, this proceeding was initiated in 25.
Yes.
The first, it is not that the proceedings were conducted behind his back. In fact, I want to show your lordship, he's participated in the proceedings. Before the forensic auditor prepared his report, the forensic auditor called upon the petitioner.
That's correct. That's correct.
And he's replied on merits.
Yes.
Your lordship has seen his reply.
It is the allegation by you also, because they have not provided the document.
They are not my lord. Two things I want to show you. Kindly see first the letter at page 27, which is of 26th May 25.
Yes.
The forensic auditor writes to the petitioner
Yes.
for clarifications. And not only that, he gives the entire particulars of the transactions on which clarification is required.
Page 27.
This runs from 27 to 58.
Yes.
Every document is given. All that is required to is clarify on these documents.
No, that's
and
correct.
these transactions.
No, that's correct. You have given this subsequently after receipt of this document, non-receipt of the document, you have prepared the forensic audit report.
No, my lord. Kindly see page 29.
Yes.
I give him all particulars of the transactions which he has entered into. The forensic auditor gives him all particulars of transactions which he has entered into, which according to us are fraudulent.
Correct.
That is all that he has to explain. It's not that he doesn't have documents. He knows exactly which transaction is being referred to, why it is being referred to. The remarks are there. And he replies to this. Kindly see his reply at 59 on 29th May. Kindly see supporting documentation.
No, 27 to
58.
58. That is your question.
These are questions.
Question you have given to the petitioner. Correct.
We have given to the petitioner. Kindly see 38, for example, now. Kindly see 38.
38.
Please come to 38.
Yes.
We have reviewed the bank statements provided to us and have observed that the borrower has made payment to various individual firms whose proper details cannot be obtained from the web search or public domain. Summary of payments made to such individual firms have been shown below.
Yes.
Global Trade Company, 1 crore 2 lakhs. We have found one company trading in paper, etc. from Delhi. No concrete results found. So all these companies, payments have been made.
Yes.
From on whom we have not, the forensic auditor has not been able to ascertain.
Yes. Correct. Then.
So on all these companies, particularly his details are sought from him. Please tell me, why have you made payments to these companies?
Okay.
Now kindly see page 59.
$59. 59 is a reply.
Yes, 59 is a reply. Now kindly see, may I just place the reply? Supporting documentation.
Yes.
As regards supporting documentation, It is regretted that the same cannot be provided as of now due to the fact that in connection with a legal case arising out of so-and-so, all these documents are attached. Now kindly see 2. So he says, I can't give the supporting documents, but he's at least required to give his observation with regard to the transaction. I can, my lord, kindly understand, I make an allegation in my plaint that I have paid you 5 rupees. Now the supporting document of that is a bank remittance. I cannot give the bank remittance because it is attached. But that I have given you 5 rupees, or the purpose for which I have given you 5 rupees is for him to explain. And I'll show your lordship, he says, I took all decisions. Please exonerate my other board members. So it doesn't give any explanation. One is I cannot give document, but the other is where is the explanation? Kindly see now observation in connection. He answered on merits. It has been a very long time of about 7 years since the sealing of units and seizure of records. Hence, you would appreciate that it would not be possible to provide detailed clarification by way of recollection from memory as regards the transactions as mentioned under various heads. Now, can you see? However, on an overview of the transactions, it is clarified and stated that all the transactions are related to and in due course of normal and genuine business activity of the company. It may be broadly classified as under. PSL has these 2 segments. The transactions certain to procurement of ENA, packing material, PET bottles, labels, etc. Company has office at Kolkata and Bangalore, Nariman Point, Mumbai. Fastest growing corporate offices. As regards production unit, I have all these units. Substantial capital expenditure had to be incurred by the company for factory infrastructure. All transactions out of normal course, true and fair corporate purpose. Procedural lapses arising out of accounting entry, statutory represent had been inadvertent. Kindly see, procedural lapses arising out of accounting entry, statutory representation of data, if any, had been inadvertent and without any malafide intention on the part of the management of the company. Then it would be relevant to state following better insight. This was a listed entity
Yes,
with.
he has given the reply. Then what is
So he has given the reply.
Yes. Then you issue the show cause.
Then I have issued the show cause.
What has happened to receipt of the reply?
Beg your pardon, Mills?
What has happened after receipt of the reply?
The forensic auditor has prepared his report.
Correct.
And he has given him a show. And on the basis of that report, my lord, kindly see. Forensic auditor says you've entered into transactions with all these companies. Before I show, kindly see once this reply to the show cause at 67 once. Starts at 67.
Now, Mr. Thakkar, see, simple thing. You have asked the clarification from the person concerned.
On transactions.
On transaction, whatever it may be, transaction. He has given the transaction or not given transaction, you're satisfied, you're not satisfied. Thereafter, you have prepared a report.
Yes.
Correct. You have prepared the report. On the basis of the report, you have issued the show cause notice.
Please, my lord.
Correct. If you issued the show cause notice and that report has not been supplied to that.
No, that is not his case. Report is not. Forensic audit report supplied. It's not his.
That is the case.
No, no. He said, I don't have documents on the basis of which I can defend myself. He says, I don't have documents on which I can defend myself. Then, my lord, it would be Rajesh Agarwal and all that would have kicked in. I would have been out of this court by now.
That's why I'm asking.
No, no. His case is, I don't have documents to defend myself.
Okay, okay.
Now, if he doesn't have his defense, that is his problem.
Okay.
That is not my outlook.
Okay.
And kindly see, my lord, page 69 once. Kindly see paragraph 3 at 69. I being, kindly see this paragraph 3 at 6. Now, kindly see the paragraph beginning, I would also like to state.
Yes.
These are the other directors.
Yes.
Now, kindly see the sentence. I being promoter of the company was solely involved in all business policy decisions. I was also the sole signatory to the conduct and operation of all bank accounts of the company.
Where from you reading?
Page 69.
Mm-hmm.
Paragraph beginning, third paragraph on that page, I would also like to state.
Okay.
Now, kindly, I would also like to state that Arup Thakur and Subrata Basu, who are the other directors to whom I had given notices, had been employee and professional directors without any shareholding, without any involvement in the day-to-day. Your lordship has that?
Yes.
I, being promoter of the company, was solely involved in all business policy decisions. I was also the sole signatory to the conduct and operation of all bank accounts. So he is the person who has all knowledge.
Yes.
His only case here is that I don't have the documents to defend myself.
Correct.
Now I have, my lord, before the forensic auditor prepared his report, he gave him particular transaction. And your lordship has seen the reply he gives. If he is the person who took all decisions, he ran the company like a one-man show. He's saying, I am the only person. Don't even trouble the other directors. I have signed all bank accounts. Then, my lord, is that person not supposed to know why he paid 1 crore to a non-existent company in Delhi? That is the case of the forensic auditor. All these companies to whom you made payments, they are not to be traced. Kindly see 38. This I was showing you, just showing your lordship just by way of an example. Kindly see 38. Global Trading Company, 1 crore 2 lakhs paid. Global Corporation, 1 crore 66 lakhs paid. These are not 5,000, 10,000 that I bought stationery and pen and paper. 1 crore rupees payment made, and his reply is nothing. He doesn't say that Global Trading Company, I bought alcohol or I bought drop, I've got packing material.
What would be the situation if the official liquidator is appointed and the documents will be
Documents are all seized now, grateful my lord. If the documents are seized, has he even, what does he say? He says bank should have.
What is the effect of that?
My lord, it is for him to establish his defense. If a document, if my document is seized, did he make any attempt to get those documents? He's just passing the buck to the bank that you provide me the documents. I am going on the basis of his filings. He's a listed company. He's made disclosures on the stock exchange. His audited balance sheet is there, which he has signed. I have his bank statements. And I find that all these payments are fictitious. Now, where does he make the attempt? He was behind bars. Now he says, I was behind bars for 8 years. Now, behind bars, he was writing to me. Kindly see that now. From behind bars, he was writing to me and giving explanations for his acts and conduct.
Behind bar is the safest custody, safest place.
Safest place. Now he's writing to me behind bars. Kindly come to page 70. This is the reply to the show cause now, which your lordship sees that starts at 67.
Yes.
Now kindly come to 70, please.
Yes. January 2018, I was communicated.
During my custody, kindly come to as a middleman. I would also like to state as under, your lordship. Now, okay. During my custody period in January 2018, I had communicated with all consortium members, banks, giving my humble submission, clarification and viewpoints. So behind custody, he could give clarification and viewpoint. After custody, when he files the writ petition, he doesn't know anything. Which was duly received by all member banks, including your bank. Copy of my communication dated 15 January 2018 may please be perused. Then kindly see. Next, I have communicated with Bank of India, one of the member banks. Read my letter dated 1st June 22. My learned friend corrected me till 24 he was in custody. All this he was running his business from behind bars, clarifying various issues. Copy of this letter may also be submitted. Then I had submitted an OTS proposal with State Bank of India. Read my letter dated 7 July 21. Behind custody. When he comes out of custody, he makes no attempt to obtain document from anybody.
So since when, which date to which date he was in custody?
He was in custody, my learned friend says, from 2017 to 16th October 2024.
November 17 to 16th October 24.
16th October 24.
Yes.
So, my lord, when he was in custody, he was giving clarifications, he was giving viewpoints, he was giving OTS, he was clarifying issues. Now, after he comes out of custody, and in 2025, 26th May, at least 6 months after he's come out of custody, after receiving this notice of the forensic auditor that please give clarifications, what step has he taken, my lord, to obtain documents from the liquidator?
Yes.
If documents are seized by the police authorities, my lord, I can make an application to court and have copies of the seized documents. That these are your relied upon documents. Please give me copies. This is the pressing urgency. No attempt made. The defense has to establish his defense.
Yes.
He has to give an explanation, an ample opportunity. Normally, he attends the oral hearing, which is also given. Before classification of fraud, he attends the meeting. After this meeting, he gives his written submissions.
Where is the reply?
Yes. Written submissions after attending the meeting. In the supplementary affidavit now. Page 8. Where is the order? The letter at 19 January 2026, my lord. He gives a written note of submissions. In connection with the above referred letter for notice of personal hearing, I personally appeared before you today, that is 19 January about 11:30, and made the following submissions amongst many others which had arisen out of the show cause notice.
Yes.
And then kindly see B, payment to shell struck off entities, suspicious transactions. This is a point by point dealing he has done.
What is the civil SLP pending before the?
Beg your pardon, my lord?
What is the SLP pending before the
I
civil
don't know, my lord.
appeal?
And that is,
This.
if he has completed, I'll answer.
For recovery of properties of PSL, they are mortgaged with, I once again category request and other consortium members in civil appeal number so-and-so, which is sub judice. My lord, it appears that after the instructions which I have is the enforcement directors had also attached his properties. The enforcement DEO was the Department of Economic Offences, State of West Bengal. And then, my lord, the properties were also attached by the enforcement directorate for money laundering, obviously, my lord. And this appeal, my lord, he has challenged the impleadment and he requests the bank that you also go and get yourself impleed. This has perhaps been disposed of.
Okay.
This appeal is perhaps.
Yes, anything further?
So, my lord, this is, in my respectful submission, my lord, this argument that bank does not give me documents does not lie, because bank does not have the documents. Number one, bank proceeds on the basis of audited balance sheets, which he has filed on a verification of his books of account on the basis of the bank ledger and the audited balance sheet, and seeks explanation. He gives explanations which are not found acceptable. And it is for him, if he has to justify the transaction, what he has not taken any steps. And even in this writ petition, your lordship will not see any challenge on merits on the decision.
Yes.
Or on the decision-making process.
Yes.
Those are my.
No, my lord. First submission, kindly comes to page 60 of the writ petition. Well, my learned friend invited your lordship to this document. This is, my lord, addressed to the forensic auditor. Management comments. My learned friend only invited the first sentence supporting documents part, not the entirety of it. I am placing the entirety. As regards, this is page 60.
Yes.
This is page 59, I'm sorry. Page 59, paragraph 1.
Yes.
As regards supporting documentation, it is regretted that the same cannot be provided as of now, due to the fact that in connection with the legal case in reference case number such and such, Enforcement Directorate, Kolkata, the Directorate of Economic Offences under Ministry of Home Affairs, Home and Hill Affairs, Government of West Bengal, has sealed the registered office at 7 Red Cross Place, 3rd floor, Kolkata, and all other production, unlike Pincon Spirit, etc., along with business units of the subsidiary associates companies with distributors such and such, and may not engage in liquor bottling, etc. Then the next sentence. Further, with such said sealing the units, the DEO had seized all the records like books of accounts, documents, the last 3 sentences of this paragraph, vouchers and computer systems unilaterally without any reference to the management of the companies. Since the said legal case is sub judice, no further comments in this regard could be made. Now, this is before the forensic auditor. Now, once again, I repeat, my learned friend has invited your lordship to certain excerpts of various portions of the so-called responses, if that may be termed as response, without indicating, at the outset that my client, whoever he is, the entire thing is with the liquidator. The liquidator wanted to detach those documents. I invited your lordship's kind attention to that. That order has been allowed. From that order, which allows him detachment, the matter has travelled to the Honorable Supreme Court of India. At the instance of, who is Binay Kumar Singhania? Binay Kumar Singhania was the liquidator. and Binay Kumar Singhania versus Directorate of Economic Offences. The matter is pending consideration in the Honorable Supreme Court. And the matter is fixed, I am told, on instructions, oral instructions, of course, sometime in the month of April. Now, today, the factual scenario is...
But against which order the SLP? That order?
Yes, the order permitting detachment. The order whereby, that was allowed. But that order has now been carried. Now, two things. I don't think, I need to address your lordship on this, subject to correction, the moment a liquidator has been appointed, the company has no independent existence. The directors have no role to play whatsoever. Everything is in the custody of the liquidator. I bring it to the notice of the forensic auditor, and if your lordship sees, these comments, the management comment portion everywhere is blank. Please see, the relevant portion. Starting from page 27, it begins. The observations. This is the observation. Please see. These are the allegations which are referred to. And please see management comments, page 35 onwards. At every stage, management comments are blank. Serial number 1, management comments for transactions entered into with strike of company entities blank. 2, serial number 2 begins at page 35. Then again, page 37, management comments are blank. Serial number 2, Roman 2, management comments are blank. At every stage, the management comments are blank. Because the management indicated to the forensic auditor that it is not in a position, the lock, stock and barrel, every document, every papers, every computer is not within their custody. They are not in a position. Reference to certain previous communications made in the year 2018 or 2019 does not have cut much ice in as much as in the year 2020, the liquidator on being appointed, the entire exercise is out of his jurisdiction.
Okay.
Now, therefore, my learned friend says that the decision-making process has not been questioned. I say, with greatest of respect to your lordship, if the decision-making process is fraught with illegality, irrationality, and procedural impropriety, a judicial review under Article 226 is definitely, warranted on facts. Here, your lordship is looking at a issue where, apropos of forensic audit and relying on the forensic auditor's report, a show cause notice is served, to which a response, a cryptic response, not a detailed response furnishing all details and papers. There may be n number of allegations, but those allegations prima facie. I say that I can't respond to the allegations because the documents are not with me. I am unable to give a response. Despite that, relying on the forensic audit and relying on my response to the show cause, ultimate conclusion at page 14 of the supplementary affidavit, on facts and in the circumstances, cannot be countenanced by any stretch of imagination. Okay. There is absolutely no reason forthcoming from their end apart from a conclusion reached that he is fraud. And the forensic report, I invited your lordship's kind attention to, in this SBI matter, innumerable places it's incomplete. It is incomplete. It records it's incomplete.
Okay. That's
so
all.
That is the sum and substance, insofar as Union Bank of India is concerned.
Okay. What about the others?
Insofar as State Bank is concerned, I need to show your lordship.
May I just
No.
State Bank has not come to that 14. Union Bank of India is the only bank which has concluded that this conclusion that it is a fraud.
Yes.
Or they are fraud. Insofar as State Bank, other banks only. In Bank of Baroda, I am told it is there. And
Your lordship, on the last occasion when this matter was taken up, my lord was pleased to, as the bank took time, she was pleased to direct the bank not to report it to RBI. So my lord has taken instructions. The reporting to RBI was done the day after the classification was done and much before your lordship saw.
The counsel for the parties have concluded their argument in connection with 26107 of 2025 within bracket Manoranjan Roy versus Union of India and others. Full stop. In the set date application by an order dated 10th of March 2026, this court passed an interim order restraining the bank from taking any action in terms of the order dated 21st of February 2026 by reporting to the RBI and law enforcement agency for further investigation in the matter till the next date of hearing. Learned Senior Counsel appearing for the Union Bank of India submits on instruction that immediately after the order passed by the bank, the order was already communicated before the order passed by this court. Please. As regard WPA 26107, hearing concluded, CAB. Hearing concluded, not CAB. Hearing concluded. As regard the other writ matters, when you will argue?
But with regard to the State Bank of India, I have concluded my argument only 2 points, Biro.
Come tomorrow. Other matter. Let the matter appear.
On any day, your lordship will not want. But only one thing, it is my duty to point out before your lordship. In Union Bank of India matter, this writ petition was apparently carried to your lordship's court and presented in your lordship's court sometime in the month of November 2025. Thereafter this classification or whatever took place on the 14th of February. This attempted overreach kindly records, that this communication to the RBI is an attempted overreach.
Okay. Let the matters appear on 31st under the same matter.
The personal hearing, there's no overreach, my lord, because I'm a bank, I'm just.
I have not recorded anything.
19 January personal hearing, 18 February matter taken.
I have not recorded anything. What you
February where matter was taken up? It was taken up on 10th of March.
18 February adjournment taken on your behalf. The order sheets will speak for themselves. Grateful, man.
Grateful to your lordship.
Yes.
Malan, I will start your lordship.
Not start, only reply.
Yes. That's only on reply. Two things.
Three, you have to give reply. First, with regard to the you have participated in the pre-bid proceedings.
We have gone into the pre-bid meeting.
But you are not. Why you not mention? Why you not mention all the things in the writ petition? One thing. Second thing, with regard to the 239 capital A Delhi.
Yes.
This is the second, and fourth is with regard to
your lordship. There is one thing which they did not answer at all. That is the primary thing that I must indicate. No, the fact that we have gone into the pre-bid meetings, I have not raised anything that is out, which goes beyond that. I have not said anything in my writ petition here, and I have not moved here on anything which goes beyond. Yes, I asked them to remove that. That is all that was.
No, that's why. See, that's why they have taken the plea. You, before the pre-bid, you have suggested your proposal.
Correct.
Your proposal was not taken into consideration, rejected. Refused or something has been, that was not your proposal.
My only contention is
that was not your proposal. So you had the knowledge on that and you participated in the tender. After that, whether you have a right to challenge that.
I am not here, your lordship. We have not challenged. We are not challenging at all any of the terms. If your lordship
kindly see the fair one. Yeah.
I have seen that. We have not moved that. Your lordship, we have not moved that. We have not moved any of those prayers. We are moving, your lordship, what tenor of my senior submissions also. Your lordship will come to prayer C. Your lordship will come to prayer C.
Yes.
To set aside bids which are not in conformity with the technical qualifications. That is all that we are talking about, being treated equally. We have to be treated equally, irrespective of the fact. All the judgments which has been placed before your lordship,
does not take away from the fact
Yes.
that all participants have to be treated equally.
Yes.
That is all that we are asking for.
Yes.
Now, in that realm, your lordship will come to first page 64. That is the technical qualifications which have been mentioned.
Page
64.
Yes. That is the for A, B, and B.
Yes, for A and B, they have given interpretations of how the qualifications. If your lordship looks at four, the factum that the qualification is not for 4A and 4B is again not clear. Just looks at it. But even if that is the interpretation being given, we are only at L2 today because we are asking to be treated equally first. Now, first looks at B. Bidder, and there is no answer to this argument. There has been no answer by any of the respondents, either the Election Commission or the L1, L2, L3 on this point. Bidder should have executed at least 3 full state orders of live web streaming. Now, your lordship, full states of live web streaming. Now, this regulation of full live web streaming comes only before the elections in Bihar in 2025. After that, there has been only Bihar elections. There has been none otherwise. So there couldn't have been. There have been instances in which we have pointed out. We have done it in Kerala. L2 has done it in one state where specifically there was a requirement in the contract which was given, floated in the tender. But this was not true for everyone. Now, what is the answer to this? There is no first answer to this. And then they say, whatever
No, they have given the answer. Their answer is that 2020, before Bihar election, there was no 100%. And prior to that, whatever the experience, either a 50% or 40% or 60%, that has to be taken as a 100%.
Your lordship, that is there a
that is a clarification which they have given.
That is exactly what I'm saying. That is, they have given. 4B, a reading, perusal, any reasonable perusal, does it suggest that? No. Second, is there a clarification? They have 21st, your lordship also remembers, we have shown page 105, in which there is a corrigendum. 21st is the last day of bid submission. On 20th, they changed the regulations from different states to states. Why? Then L2 can apply. Otherwise, L2 cannot apply, because even otherwise, whatever their submissions is, they cannot be done. If such is the norm that they can change, I am not again challenging the corrigendum. Your lordship, again, pre-bid, I have participated. I'm not challenging the corrigendum. I'm only asking to be treated equally.
So your prayer is not, you're not pressing.
At this moment, we are pressing.
No, not at this moment, because I will not keep the repetition pending. I will dispose.
No, I'm not. Your lordship will.
That's why if you say that you are not pressing the prayer, then I will record.
Your lordship, may I just indicate what my submissions are, and then I'll indicate. Your lordship, then, is there a clarification with regard to 4B that it is only what they have asked for? There is nothing in their bid submissions also. Nowhere it is said that this was asked for and that is why I have done this much. Nowhere, none of the bidders, including us, nowhere in the bid pre-bid meetings was this suggested. Nobody has made those clarifications that the live web streaming, no one in their documents, that the live web streaming, only that much which was asked for we have done. No. Everybody has gone with their general experience in those when calculating 3 full states. And that is there. Nobody has made an alternate suggestion. All that is being argued today by the Election Commission is that we are satisfied because those didn't ask, the Election Commission had not asked for. But that is not 4B. Basic understanding, I'm taking a reasonable, the most relaxed understanding of 4B cannot be this. This is the first point with regard to equal treatment, and all of us do not have this qualification. If this is the requirement, if this is relaxed, then I am also through.
Your Lordship, then we come to. Now then comes, Your Lordship has a constitution.
Minimum, this book can be. This book can have been. Other book cannot be.
Your Lordship, the important thing now is a lot of suggestion has been that there is some kind of an understanding that Delhi is a deemed state. And for that, reliance has been placed on a judgment, paragraph 14 to 19 of a judgment. 2 days back, there was, I think, a reporting that one person's marks had been cut, in a law exam, a person's marks had been cut. And when, with regard to the 9th schedule, whether it can be challenged or not. And when it went to the Supreme Court said when come to the Supreme Court and the High Court and everybody has a differing opinion on it, and we have a differing opinion and the other person has a differing opinion on it, it is not reasonable to have that interpretation. So everybody is correct. Today here, what they are asking, showing that interpretation clause, that to understand that Delhi is a state, that person must have read into judgment of paragraph 14 to 19 and interpreted it that way. And Your Lordship will, I'll take you through that judgment. Paragraph 14 to 19 says nothing of the kind that it is a deemed state. It only says about an electoral processes and other things, the rights, additional rights which Delhi has. Now let's look at the Constitution, what the Constitution says. Easiest thing to see for getting an interpretation, it cannot be a subjective, anything unreasonable interpretation also, even if the right of interpretation is there with the Chief Electoral Officer. Now Your Lordship sees Article 1. Article 1 of the Constitution. So that is the check. Yes, Your Lordship, Article 1. First time I read so much about Article 1.
Yes.
Your Lordship sees India, that is Bharat, which is the more popular thing about Article 1, shall be a union of states, and in that it says the territory of India, Article 1(3), territory of India shall comprise A, territory of states, B, union territories specified in the first schedule. Union territories specified in the first schedule. Now Your Lordship comes to the first schedule. I don't know, Your Lordship has fine. Schedule 1.
Yes.
Your Lordship. Now, which is the first entry, Your Lordship? Delhi. Delhi. The Constitution.
Yes, the first schedule.
The first schedule clearly says this is the Constitution. The Constitution, if somebody is to make an interpretation, rather than understanding paragraph 14 to 19 of a judgment, that person will refer to the Constitution. What does the Constitution say? And thereafter, Your Lordship, we come to 239 AA.
Just a minute. Then schedule.
Your Lordship will give me.
Apropos this, as what my learned friend has just now shown, kindly come to paragraph 44 of the judgment of the Supreme Court placed in this regard to justify an interpretation that Union Territory does not include Delhi. They said Union Territory, but did not include Delhi. Kindly come to paragraph 44 of this judgment. The concurring at page 41, paragraph.
Yes.
the concurring opinion of Justice Chandrachud in the 2018 Constitution Bench expressly discussed this aspect and held that no single homogeneous class of union territories exists. Instead, the union territories fall into various categories. The judgment, the judgment of the majority of NDMC, state of Punjab, also holds that all union territories are not situated alike. The first category consists of union territories which have no legislature at all. The second category has legislatures created by law, enacted by Parliament under the Government of Union Territories Act. The third category is Delhi, which has special features. Third category of Union Territory under Article 239 AA. Though Union Territory of Delhi is in a class by itself, it is certainly not a state within the meaning. It is like saying past experience of supplying in India and somebody supplies in Pakistan and the tendering authority says by India I meant Indian subcontinent. So Pakistan will be sufficient.
Why you are going to the Pakistan? Why not Bangladesh?
Yes. That's closer. That's closer. Pakistan generally has a greater impact on us when we mention. Then paragraph, apropos this, kindly see also paragraph, the previous paragraph, para 41. By the Constitution's 69th, page 41.
Yes.
By the Constitution 69th Amendment, 239 AA was inserted in Constitution. It introduced a unique structure of governance.
Yes.
For NCTD via vis-a-vis union territories. The statement of objects and reasons provides as follows. After such detailed inquiry and examination, it recommended that Delhi should continue to be a union territory and provided with a legislative assembly and a council of ministers responsible to such assembly with appropriate powers to deal with matters of concern to the common man. The committee also recommended that with a view to ensure stability and permanence, the arrangements should be incorporated in the constitution to give the national capital a special status among union territories, among the union territories. One of the three categories, one without legislative assembly, one with legislative assembly, and one legislative assembly plus some more.
Yes.
Then paragraph, my lord, paragraph, yes, paragraph 48, page 43.
Yes.
Therefore, we are unable to agree with the argument of the Solicitor General that the legislative power of NCT does not extend to those subjects which are not available to the Union Territories as a class, because 239A employs the term any such matter is applicable to Union Territories. The analysis in this section clarifies that there is no homogeneous class of Union Territories with similar governance. So Delhi has, as has been said in paragraph 44, there are three categories, and Delhi happens to be one of such categories. In fact, there being, as my friend, my junior has shown, Article 1 specifically defines
Union
territory. If they had to treat a union territory as state,
That
then
is to be amended. That is to be amended.
That has to be amended. The constitution has to be amended. Now, apropos this, Lordship, I will try to make it as short as possible. Lordship, the judgments they have cited on the proposition that they had an interpretation given of a term of the NIT by the tendering authority is kind of sacrosanct. That is the tendering authority's domain to interpret a clause. So by union territory, if I mean union territory minus Delhi, that's good enough interpretation. That is not the law. Lordship, I am constrained to cite one judgment very recent, because this argument was made, which had I anticipated this argument, I would have certainly cited the judgment earlier. Sugruja da Sugruja. This is a judgment, very recent judgment, reported in SCC online. Page 20, paragraph 24. SCC reference paper, I have to copy This is 2025 SCC online 2916. We are of the unhesitant view. We have the unhesitant view that an eligibility criteria should be clear and unambiguous. Otherwise, it may lead to arbitrary exercise of power by the state. And in this case, it can't be more unambiguous. It's very clear. Article Union disqualifying a tenderer who would otherwise meet the eligibility criteria. In West Bengal State Electricity Board versus Patel, this court declared that to hold that a state or its agencies can reject a tender for breach of a term or condition in the tender document, which is not explicit in the tender document, is to give room to the state or its agencies to arbitrarily reject tenders, even when clear terms or conditions of tender documents are complied with. Therefore, it is the responsibility of the tendering authority to issue clear and unambiguous instructions in the NIT. As pointed out by this court in Patel Engineering, when there is vagueness or subjectivity in the norms, it may result in unequal and discriminatory treatment and provide for room for manipulation. And now, Lordship kindly sees, I propose this, page 31, paragraph 26.1. The 10th line also in Datta Associates. In Datta Associates Private Limited, this court observed that whatever procedure the government proposes to follow in accepting the tender must be clearly stated in the tender notice. The consideration of tenders received and the procedure to be followed in the matter of acceptance of a tender should be transparent, fair, and open. There is no dispute to the proposition that the tender implementing authority is the best judge to understand, 27, and appreciate its requirement and interpret its documents. In AFCONs and Bharat Coking Coal, as well as in subsequent decisions, this court has upheld the principle observing that ordinarily constitutional courts should defer to the understanding of the tender inviting authority of the tender documents. However, this principle has its own limitations. If the interpretation of the tender inviting authority or its understanding of the tender condition is vitiated by malafide or perversity, there is no question of a constitutional court showing deference to such understanding. Likewise, if the interpretation of the tender inviting authority of a particular condition of tender, such as an eligibility criteria, as in the present case, is irrational or absurd, leading to arbitrary consequences, it would be the duty of the constitutional court to interdict such a decision-making process. To hold otherwise would render the very object. Now, Lordship, what was the gray area here? Much less, Lordship sees paragraph 18. There was actually scope for interpretation in this case, which I handed up. Paragraph 18, the eligibility criteria was prime contractor. Prime contractor, the absurdness in our case is much more because it's an Article 1 definition to say it otherwise. Paragraph 18, clause 1 of the pre-qualification document lays down the qualification criteria. It has got two parts, clause 1A and 1B. It says that to qualify for the award of the contract, each prime contractor in the same name and style must have achieved in any one financial year in the last 5 years a financial turnover so and so. Now, Lordship, kindly come to the next paragraph, 19 and 20. Paragraph 20. The bone of contention centers around the meaning of the expression prime contract. We find that the phrase prime contract is not a defined expression, either in the pre-qualification document or the NIT. In our case, luckily, it's constitutionally defined. If that be the position, the common parlance test has to be applied. Expression prime contractor in the context of NIT would mean that the tenderer who has submitted the tender in terms of the instance. If there's more than one contractor working together, then it would mean the contractor who is primarily responsible for the contractor. The eligibility requirement is that a prime contractor should have its own name.
Yes.
So in this kind of a case, the joint ventures experience was not taken into consideration by interpreting prime contractor otherwise. The bottom of this paragraph 20. In the incident case, the appellant is relying on his share of 49% in the joint venture, which is well above the 50% probable amount of the contract value. But respondents are of the view that appellant cannot claim the benefit of such experience because such experience was gained as a member of the joint venture, not individually.
Yes.
Therefore, it becomes important to understand the concept of joint venture. So, Supreme Court, in spite of that, where there was scope for interpretation, struck it down. Either it's vague, if it's precise, then you got to stick to it. And here it was. And my lordship, apropos this, kindly sees what was their argument in the division bench from the order passed by your lordship, which was placed by them. Lordship, this is Shampa Sarkar presiding over the division bench. Lordship kindly comes to page 14 of this judgment. I think that's it. Page 14, paragraph 35. They were justifying three different states. Kindly see paragraph 35. Or paragraph 35 first. Past experience is an important criteria in tender matters. It not only allows the tendering authority to assess technical capability of the financial ability, but also reliability in order to ensure so and so and so. The work involves training. Next sentence. Thus, past experience of having performed similar work in three other states will definitely throw a light on the reliability. That was a pre-amendment. Three different states was changed to three states. Three states where L2 could participate with that 2 union territories. And to justify it there, Lordship, apropos this, kindly sees paragraph 22. This argument was upheld at para 35. The argument is para 22. He next, as Mr. Mukherjee, para 22, page 8. He next submitted that the election process in West Bengal was a difficult one, and the bidder having experience of execution of similar work in three states would be capable of providing the service as contemplated under RPS. Greater the experience of having executed similar work of similar kind of work in three other states, better would be the performance in the decision. And this person has one state. What is the state? Tamil Nadu and Union Territory, both in Delhi.
No, Tamil Nadu.
State. Page 197.
That is the Tamil Nadu, Delhi and Delhi. Okay.
Delhi. Not even three different. That was altered the previous day to enable L2. Possibly that was not. And it was justified, it should be three. So in my humble submission, in this case, there can be no justification for if either you strike out L2. But and my lord, Lordship, since there are several judgments cited that the NIT terms cannot be challenged in intent. The Lordship may recall, at the beginning I said, though there are prayers, I am not going on the NIT terms. I am on their decision-making process as a perverse and arbitrary decision-making process. If you take L2 with one state and 2 union territories, take me also with one state and 2 union territories. At least I have different union territories. Either strike out L2 or take me in. I am not pressing the other points where they have argued because there could be an answer, so I'm confining. That's all.
Thank you.
My lord, may I just take 2 minutes, my lord, apropos this?
One second, paragraph 83 of that Chandrachud judgment, 23(9) SCC, paragraph 83.
83.
Paragraph 83, that the page number, internal page will be 66. Para 83, I don't know which is the Judge.
Yes.
The last 4 lines of para 83. While NCTD remains a union territory, the unique constitutional status conferred upon it makes it a federal entity for the purpose of understanding relationship. Remains union.
Yes.
My lord, just 2 minutes. My lord, kindly take, my lord, the judgment which was cited. My lord, Surguja Bricks. 'Surguja' 'Bricks'. 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 'Sur
Yes.
My lord, paragraph 27, my lord, recognizes the principles in AFCONS and Bharat coking coal.
Yes.
And my lord says, my lord, unless my lord the interpretation is irrational or absurd, which leads to an arbitrary consequence, my lord, that they should, my lord, there cannot be an interdict to the decision-making process.
Yes.
So, my lord, what has to be satisfied is irrational or absurd, leading to arbitrary consequence.
Correct.
Now, my lord, here we are concerned with a tender relating to an assembly election. And, my lord, the assembly election where, my lord, there is, my lord, total, my lord, election, my lord, is, my lord, the territory of, Union Territory of Delhi. Which is why, my lord, that interpretation has been given. And this is evident, my learned friend cited 83, para 83 also. Kindly now, my lord, have a look at, my lord, para 84. Which recognizes, my lord, this, my lord, election. Majority of held that while NCTD could not be accorded the status of a state, the concept would still be, we have dealt with conceptual essentiality of federal cooperation. So, my lord, they have elected representatives, my lord, in the assembly. Otherwise, my lord, union territories don't. Even for Pondicherry, my lord, there can be nomination and, my lord, election.
Yes.
So, my lord, it's held, my lord, separate, my lord, to, my lord, Delhi. And, my lord, that schedule, my lord, Delhi was different, my lord, when, my lord, the constitution, my lord.
I am not joining issue. If they had said union territory except Delhi, I would have understood. But you call it union territory, don't say except Delhi.
What would be effect? What would be effect of your writ petition once the work order has been issued?
Also get it or L2 put down. Let the others remain L1 and L3, like in the 25 Supreme Court which I cited, even after signing of contract.
Yes.
And everyone has got it. It is not only L1.
Hearing concluded. See.
And in the portal, post portal, this and post filing of writ petition.
Thank you.
Obliged.
Yes. Case my lord permits, my lord, that jetty matter, inland waterways. Now, I was doing the business. I'm still doing, but yesterday they came to stop the business.
Which matter?
My lord, this is the matter I mentioned yesterday, that a notice has been received that the business will be shut down, that the 3 jetties will be shut down, not for public.
I have filed an intervention application. Well, let the matters come up together.
Stop their business from 15, and I filed the and they filed the petition. But so I mentioned Lordship said Lordship will look into it and place it. I've got this letter from the government has now issued this letter. Lordship, can you take a look? Oh, copy can I share with you? Education. Even the state feels that this is something about arbitrariness apart. Even the state requests to keep this suspended for some time. Because there'll be a
state has nothing to do with this.
No. This is a public law and order, and also air pollution. The power supply.
This to be issued. This is under Inland
I can't get this issue.
State has nothing to do with this. This was informed to them in November 2025. This is under a project which is monitored by the Prime Minister's office. It's a part of a.
Let them not do anything to
No, my lord, this will affect my business. I am an intervener. I have filed an intervention application. If this petition succeeds, my business will be closed down.
Takes it up. That's all I am saying. They do not jeopardize it because after 15th also I am doing business.
You can keep it whenever, my lord. But this is definitely created by the.
How can this is censored by the principal secretary?
Project.
Principal secretary power department.
How the principal secretary issued this?
That's right.
This is the principal secretary power department because Lordship has seen. Third line, it is apprehended that such immediate enforcement may disrupt fly ash evacuation, adversely affecting power generation from 600 megawatt Haldia plant. Because the entire fly ash generated from Haldia plant is exported through those 3 jetties. As a result of which
jetties are not even being touched. It is what they use to transfer.
If they say that,
Okay, what do you want now?
I was saying once again, if it can be on Monday, and
Monday already 3 matters are already.
And also Lordship, a word from my lord that they should not do anything.
No.
Until Monday or Tuesday, they can't stop it. What he said, that's correct. He said that
November 25, they knew about this.
3 jetties will remain. If whatever he said that. If that is recorded,
well, this will stop my business. I have erected the new jetty. I have, my lord, invested money. I have been invited to, my lord, open new jetties and waterways. This will stop my business. My learned friend does not have a statutory right. He does not have a contractual right. He does not have a legal right. There is no promise.
Yes, but I filed it last Monday. Last Monday, we got this notice. We had to close by 15th. We got on 7th. We filed this on Monday. 17th, I mentioned, she mentioned on Tuesday, Lordship, there was no mentioning allowed. I mentioned yesterday, and Lordship said Lordship will look into it. But after my mentioning, the whole problem started.
It meant
he must have mentioned it showing some.
Upon notice.
Whether this, there is no
the problem.
What is the repetition number?
Number
6610.
6610.
Lordship will consider keeping it on Tuesday or on Friday. Thursday is anyway the holiday. Tuesday or on Friday. There is no such urgency, I'll tell you, Lordship, because from November 25, they knew this was happening.
You said you. Yes, and I'll serve you my writ petition also to you. I will not. No. Then let the status quo continue. I don't mind.
Where is given the notice?
This was given yesterday, I mentioned.
Yesterday,
or today's notice also. Yesterday.
Yesterday you moved this.
Yesterday also I mentioned in the morning I mentioned, and today also once again because of the subsequent development, Malo.
24 तारीख को 12 बजे है क्या? You are not keeping separate men. Okay, let it fix on 24. 24 of 5-6 matter के बीच में.
Very good.
24th ना? 24th.
Very good.
24th within 6 matter.
Grateful, man.
Yes, call the
34. Item number 34 of the lordship's list. The interim is till Monday in terms of.
Your Lordship, I'm seeking leave to file without the certified copy the review application.
Yes.
By Election Commission of it, which was I mentioned. Your Lordship, leave may be granted.
What?
To file without the certified copy.
Leave granted. Subject to filing of the certified copy at the time of hearing. Leave is granted to file the review application without the certified copy with the liberty to file the same at the time of hearing. Yes.
Lords, I am appearing for the respondents in this matter, Lords, opposing this.
And in this matter, Lord, in the morning, Lord, I had mentioned this matter. Lord, the only relief that I pray for is, Lord, a resolution plan has been approved in my favor, Lord, to be complied with within 14th of June 2026. Now, Lord, at the time of, Lord, the proposal, Lord, I was not aware that US and Iran will go for a war, or, Lord, the subsequent, Lord, related problems will crop up. Lord, these are the practical difficulties that has cropped up, Lord, which is coming in my way, Lord, of complying with the Lord, the resolution, Lord, stipulations. Now, Lord, the difficulty, one more difficulty is, Lord, in the plan, I had indicated, Lord, that I will be obtaining funds, arranging funds from one NBFC. I've named it in my plan also, my resolution plan also, proposed resolution plan. Lord, unfortunately, Lord, the NBFC, because of this geopolitical volatility, Lord, has also said that at this point of time, they are unable to disburse any fund in my favor. Now, Lord, this has become a chain reaction, Lord, hindering me from, Lord, complying with the stipulations of the resolution plan. What I only want, Lord, the only majority stakeholder is Punjab National Bank, the respondent number 1. In the committee of creditors, they are the majority stakeholders, 90% and above is their stake. Now, Lord, what I am before your Lordship today is, Lord, only praying for an extension of a further period of 180 days. The initial plan was sanctioned on 16th of December 2025. I shall take your Lordship, Lord, to all the papers, Lord, one after the other. Lord, 16th of December 2025, Lord, the plan was sanctioned. Till the plan was existing till, Lord, 14th of June 2026.
Yes.
Now, Lord, I want a further Lord, extension, Lord, for a further period of 180 days.
So,
in the meantime, Lord, I do not say, my Lord.
It is 14 June 2026. Where is the further action? Why the further extension?
Lord, 14th of June, your Lordship would find the date. Lord, kindly comes to straight away, Lord, page 148.
That is the resolution, impugned resolution which you challenge.
Yes, Lord, the resolution, your Lordship would find at page 59. Kindly comes to page 60 is the date of the order granting, allowing me, Lord, the resolution.
What is the date of this resolution?
Lord, 16th of December 2025. Right
Well,
hand
that's
side top. Your
That's
Lordship,
not a resolution. That's an order approving a resolution plan, my lords, by the National Company Law Tribunal.
Right.
Which is an appealable order.
Correct. That's why I'm asking. Where is that?
Lord, that starts at page
kindly comes to
59.
page 60.
59.
59, page 60, your Lordship would find the date of the order. This is the order by way of which, my Lord, my proposed resolution was sanctioned.
Where is that?
Lord, kindly comes to page, my Lord, 85, page 85. Paragraph number 32 of the said order, my Lord.
Page 85.
My Lord. Paragraph number 32, my Lord has kindly got it, my Lord. And before that, your Lordship would also find the tables, my Lord.
Yes.
So 180 days from the date of the approval of the resolution plan.
Correct.
So that takes us to 14th of June 2026. And that is an acknowledged position. Lord, kindly comes to page 148. 148.
Yes.
This 148, Lord, is basically, Lord, a part of the minutes of meeting held with the Committee of Creditors. Lord, the date
Milord,
is...
may I shorten the matter as
Mr. Chatterjee
little
is
as
leading me,
possible?
Lord.
Milord, may I shorten the matter for your lordship's kind consideration?
Yes, yes. Yes,
Milord, what happens is, Milord, I tell your lordship, I am supposed to put in, Milord, 22 crores as part of the, Milord, the resolution plan.
You are
And, Milord, I have been given...
Mr. Chatterjee, you are appearing for?
I'm appearing with Mr. Kormukar, Milord.
He's
With
leading me.
Mr. Kormukar.
Okay.
Now, what happens
Milord,
is, Milord,
I am the only respondent, Milord. I'm appearing for this.
yes, yes. Only, Milord, Punjab National Bank, Milord, is the person who can take a decision here. Let me put it that way. Milord, I am not saying that, Milord, I have a massive right before your lordship, but
That's
what
why-
I am,
How this court can interfere all these things?
no, Milord, it's on equity. I'll tell your lordship why. I understand this, Milord. This will come from your lordship. That's why I'm very, very prepared on that. Now, what happens is this extension of time, which was granted by NCLT, the NCLT, Milord, doesn't have the power under the statute to extend it. So if I go to the NCLT, Milord, there will be no fruitful purpose at all. And they will, Milord, invoke my, Milord, bank guarantee within, Milord, within tomorrow. So what I'm praying is, Milord, I'm not asking for anything. I'm absolutely on equity. Milord, I had 180 days time. I am complying with it. In the meantime, Milord, the war broke out. With the war breaking out, Milord, what happened was all my supply chain is stopped. Now, the person who gave me, Milord, the assurance, the NBFC, it's recorded, Milord, in the order itself. On the order of the NCLT order, that I am paying this money through the, Milord, the NBFC. That NBFC now is saying that since your supply chain is stopped, I will not be able to pay you money. I am not praying for anything. I am saying the whatever amount of money the bank would have gotten within this 180 days, I will pay that also, so that the bank doesn't incur any losses. The bank gets that money. I will, Milord, only pray before your lordship to extend this time by 180 days, nothing beyond that.
How the court can go do
Milord,
all?
Milord, it's only the equity court of equity can do it, Milord, in my respectful submission. I give you, your lordship, a judgment. There is a judgment of the Delhi High Court on this very point, where, Milord, the court has said that since there is a war, the bank guarantee, Milord, would not be invoked. Kindly have a look at the judgment. The judgment is pretty clear on that. Milord, what happens is, it is my company. I am the one, Milord, who is trying to protect it. If I do not pay, Milord, nobody else will pay. So the entire plan goes to the docs, Milord, if I don't pay. And I am saying, Milord, I am willing to pay.
Yes.
No, Milord, if I'm sorry, Mr. Chair.
No, Milord, if PNB
Milord,
can
no,
kindly
Milord,
agree.
I have vehemently opposing this petition, Milord. If
No,
Mr. Chatterjee is
definitely.
done,
Milord, what I am trying to say is, if whatever losses PNB gets within this 6 months, I will put in that money as well. I will give them money right now, not later.
Milord,
I
that's
will
not the
give them the
law,
money
Milord. Let
now.
me show the law.
I understand the law. Milord, I am not even going on the law. I am on equity. I am not on law. I am saying that I had to pay this money within this time. I am unable to pay. But I want to pay. And I'm showing my bona fide saying that the bank should not lose.
Yes.
Milord, may I now, Milord, respond? May I now, Milord, respond? Milord, a dangerous precedent is being set forth here. When Supreme Court time and again has, Milord, said, number one, you cannot modify the resolution plan. You cannot withdraw the resolution plan. And most importantly, Milord, my colleague will hand up judgments to your lordships. Supreme Court is saying that, Milord, writ court should not interfere in matters pertaining to insolvency and bankruptcy code, where, my lords, the insolvency and bankruptcy code is a complete code by itself. Now, Malad, the first judgment I rely upon in this, Malad, I am questioning the maintainability of this particular proceeding. Malad, the first, and I want to show from a recent judgment, Malad, your Lordship will remember when your Lordship was sitting in courtroom number 39, I had shown your Lordship, Malad, Farooq Ali. Malad, enough number of times your Lordship has quoted Farooq Ali, Malad, in the Piramal judgment as well. Malad, this is 2025, SCC online, SC 23. Now, Malad, kindly have a look at the last two paragraphs, Malad, of Farooq Ali.
You're appearing for whom?
Malad, for the respondents. Malad, the banks, Malad, the chairman of the monitoring committee and everyone.
Yes.
The Lordship sees, Malad. Now, Malad, kindly sees, Malad, if your Lordships would see, para 15 onwards, last page, apart from delay and latches, High Court should have noted that insolvency and bankruptcy code is a complete code in itself, having sufficient checks and balances, remedial avenues and appeals. Adherence of protocols and procedures maintains legal discipline and preserves the balance between the need for order and the quest for justice. The supervisory and judicial review powers vested in High Court represents critical constitutional safeguards, yet their exercise demands rigorous scrutiny and judicious application. This is certainly not a case for the High Court to interdict CIP process under insolvency and bankruptcy code. Now, in view, Malaj, the writ petitions are disposed of. Now, Malaj, my learned colleague will hand up another judgment of your Lordships in which says there cannot be any modification or Malaj extension of time after a plan is approved by the National Company Law Tribunal. Malaj, this is EBIC Singapore. Malaj, your Lordships would just kindly note the citation, and your Lordships, Malaj, Ms. Chaudhary, kindly just hand it up to the Malaj. 2021 SCC online SC 707.
Yes.
Now, Malaj, para 167 onwards of this judgment, Malaj, at para 167 onwards, kindly sees it talks about withdrawal of resolution plan, and 183 talks about the timelines under the resolution plan which cannot be modified. Malaj, I'm sorry, Malaj, I was just served with this at 12:30. So, Malaj, I quickly had to, Malaj, there are ample judgments, Malaj, hundreds of judgments. Now, Malaj, most importantly, my learned friend, senior friend, Mr. Chatterjee said, I cannot go to NCLT. After this plan is approved, NCLT does not have the power. Please come to page 136 of the company of this particular writ petition. Please come to page, Malaj, this is provided for in the order itself. Please come to page 136, Malaj. This is part of the plan approval order.
Yes. When page
Malaj,
130.
I'm only arguing on law now. Malaj, I'll show till 136 subpara 9, Malaj. Subpara 9 of the order. Lordship has that? Roman 9. Liberty is hereby granted for moving any application if required in connection with successful implementation of this resolution plan. Now, if my learned friend Malaj has the remedy to come to NCLT, Malaj, he chooses, Malaj, Mr. Chatterjee uses a very nice expression. If I go to NCLT, I will not be granted any relief because Malaj, NCLT is aware of the law on the subject in IBC, which is Malaj, EBIC Singapore. Now, Malaj, may I tell you Lordship this? Malaj, there were several other resolution applicants. He as a promoter, he came, Malaj, usually your Lordship knows a promoter of the company cannot give a resolution plan. He is barred under section 29 capital A of the code. Now, Malaj, would your Lordships kindly takes up that, Malaj, the IBC ones.
Why would that be relevant right now? Whether
Yes, of course. Malaj, I'll tell you Lordships why. He as a promoter came and approached NCLT that allow me permission to give a resolution plan when there were other resolution applicants. He was wait. Now, Malaj, Iran war, very strangely, Iran war, Malaj, to my knowledge, started on 3rd of March. Now, this plan gets approved, Malaj, in December 2025. What was my learned friend doing for 2.5 months when he's required to put in money by end of February? Now, I'll show where he has not put in a single penny. Now, Malaj, I will show your Lordships where he has to put the penny. Now, Malaj, my learned friend, Mr. Kormukar, just showed a part of the order. Now, would your Lordships just see the plan approval order? The timeline was the first payment were to be made. This is an order of 16th December 2025.
Yes.
Malaj, first payment was required to be made. Your Lordships would kindly take that order up. That chart is, Malaj, set forth what Mr. Kormukar was referring to. Please come to page 86.
Yes.
Within 90 days for the unsecured fine, kindly says 86, Malaj, payment of resolution amount, successful resolution applicant, timeline. Yes. Lordship has that?
Yes.
Now, within 90 days for the unsecured financial creditor, operational creditor. 16 December, Malas 2 months takes it to Malas 16th of February. 2.5 months till end of this thing, end of February. War on Iran has not, Iran was not fighting at that point of time. What a genuine excuse, Malad. And if this sets a precedent that the writ court would come when there is an alternative remedy available. If your Lordship keeps this matter on Monday, I'm going to give your Lordships a compilation of judgments where Supreme Court now says that writ court should not intervene when it comes to a resolution plan.
Yes.
And this writ court, when the remedy lies before the National Company Law Tribunal. Now, please take up the Insolvency and Bankruptcy Code, Regulation 37 of the Corporate Persons Regulations. Kindly see where the jurisdiction of NCLT comes here. Let's first take up Regulation 38 of the CR. It called Insolvency and Bankruptcy Code Corporate Persons Regulations. Corporate Persons Regulations.
38.
Yes, 38. It
Yes.
says about mandatory contents of the resolution plan. Lordship has it?
Yes.
Now, straight away comes to Regulation 38.3.
38.3.
3, yes, 3.
Yes.
A resolution plan shall demonstrate that. Lordship has that?
Yes, yes.
And kindly sees D. It has provisions for approval required and timeline for the same. Because your Lordship knows, Supreme Court has held now, the timelines under the Insolvency and Bankruptcy Code has to be strictly followed. Because all these promoters who are using the benefit of an MSME certificate and giving a resolution plan were trying to back out of their commitment for one reason or the other. Be it COVID, be it now the new Iran war, really Iran war. And now all other
Iran war is really new. It wasn't
now,
old.
So I'm so sorry. 3rd March, there was when the plan was approved, there was no war. And 2 months, there was no war.
Okay.
This
I'll
is a
answer
nice,
this. I'll
nice
answer
bogey, a very nice bogey.
I'll answer
nice,
this,
if I
Mr.
may use it.
Banerjee. I'll answer this.
Now, if your Lordship comes to, kindly comes to now Regulation 39, the very next regulation. And
Yes.
39, and please come to 39,
Yes.
8, kindly comes to 39.8. A person in, I'm sorry, it starts with 39 subclause 8 of the regulations. A person in charge of the management or control of the, I'm sorry, if you're
Yes, yes, continue.
39.8. A person in charge of the management or control of the business and operations of the corporate debtor after a resolution plan is approved by the adjudicating authority may make an application to the adjudicating authority seeking assistance of so-and-so in implementation of terms of the resolution plan. So Malaj also, and most importantly now section 231 of the Insolvency and Bankruptcy Code. Kindly takes that up, Malaj. 231.
Yes.
Now, Malaj, in 231, your Lordship sees bar of jurisdiction. Clearly, Malaj, and this has been interpreted by the Honorable Supreme Court. Malaj, I'll just hand up to your Lordship's court officers, Malaj, the judgment of the Honorable Supreme Court and your Lordship's, Malaj. Perhaps I have troubled your Lordships the most with these judgments when your Lordship was taking up the company matter, Malaj, the Avni project matters. When your Lordship was
You
considering
trouble my
charge.
lord everywhere. We understand
Malaj,
that.
Malaj,
And that's quite an admission, Mr.
Malaj,
Banerjee.
no civil court shall have jurisdiction in respect of any matter in which adjudicating authority or the board is empowered by or under this court to pass any order, and no injunction shall be granted by any court or any authority in respect of any action taken pursuant of any order passed by such adjudicating authority under the code.
Yes.
So today, Malaj, what my learned friend is asking is review of the order passed by the National Company Law Tribunal. Malaj, he has an appellate remedy under 61. Let's forget that for the time being. He can approach the adjudicating authority asking for Malaj extension of time by the adjudicating authority. Because Malaj, the matter is important. Because Malaj, what right do I have now? Malaj, if the plan has failed, I can Malaj file an application under section 33. Now, would your Lordship just take up that EBIC Singapore judgment and kindly see the view of the NCLAT, the Supreme Court, Malaj? Even COVID was not cited as an excuse, even at that point of time when someone wanted to modify. Now, neither can you modify a term no, you can withdraw. The consequence is under section 33. If there is a violation of the plan, an application would be moved before the National Company Law Tribunal for liquidation. Now, coming back to the facts, he's the promoter of the company. There were other resolution applicants who were standing in the queue. He is a regular habitual defaulter. Now, he gives a resolution plan which gets approved. Now, he is now wanting to default under that term again and asking for 180 days more. When Supreme Court says that IBC timeline is primary and has to be given effect to. So today, greatest of respect, allow me to file an affidavit. Please dismiss this. I can file a written notes itself. There is no question of an affidavit over here. And there is a question the court does not have jurisdiction at all. Greatest of respect,
Yes, Mr.
Well,
Chatterjee.
may I quickly answer, my lord? Firstly, 231 doesn't lie. My lord is not the civil court. My lord is a constitutional court.
Yes.
So constitutional court's powers are never taken away. My lord, your lordship will look at the Chess Association judgment. My lord, it can never be taken away. That's one aspect. I didn't think Mr. Banerjee would say that. The second part is, my lord, in all those judgments, nowhere, my lord, your lordship will find a force majeure was ever applied. In a given situation, in normal situations, we cannot back out. Absolutely correct. There is no dispute to this proposition. But we are not in normal times. Milord kindly appreciates my problem. My entire whatever is there or is Milord en route is stuck at the Strait of Hormuz. It is not going. This is not Milord an Indian ship. They need to realize my practical problem. And for this, Milord, it is
Mr. Chatterjee, that is correct, but you come to the page 136, clause 9.
Milord, Act 136, clause 9 is for the implementation.
No.
That is not for, Milord, for extension of time.
Correct.
With a lot of respect to my learned friend. Milord, if your lordship makes that clear, Milord, then I can go back to NCLT.
Go to the tribunal and put all this, say all these things before the tribunal. Tribunal will consider. If the tribunal you are having the appeal.
Milord, it gives me, very well, Milord, I'll do that. Gives me a breathing time of 7 days so that I can go back to the tribunal. Gives me a breathing time. Because in the meantime, if they enforce it, Milord, I will be nowhere. Gives me 7 days time. Within that, I will not go back.
I can only say if you want to withdraw, you withdraw with the liberty to take appropriate step before the forum. That there will be no difficulty. If you
My
want
lord,
that,
gives me that. Mr. Banerjee gives me that assurance. Milord, I will file it on Monday.
No, I can't give your lordships any assurance.
Or you want, I will
Milord,
keep
kindly
file NCLT and to come and withdraw. There will be no problem.
Very well. My lord keeps it on Tuesday, my lord. In the meantime, I'll come back.
Okay. May I say this? May just one thing. Can your lordship just note down one citation?
What opposition would you have on to that?
No,
I am
not
going
withdraw.
to the NCLT,
No.
Mr. Banerjee.
Yes. Very. Mr. Chatterjee just now said, because I know I'm conscious of the submissions that I make, writ court's jurisdiction interpreting 231, Supreme Court says writ court's jurisdiction is also taken away under IBC.
No. But with a lot of respect, it cannot be, the
Mr. Chatterjee, allow
constitutional
me.
court's judgment cannot be taken away.
Mr. Chatterjee, 20.
Court is not going to pass any.
Let's not get into that. We'll come back. We'll come back on Tuesday.
I will take the matter on merit. Otherwise, they will withdraw. They will withdraw. Otherwise, the matter will be taken on merit.
My lord, on Tuesday,
I'm so grateful.
So grateful, my lord. Extremely grateful.
So the petitioner has filed the present application, praying for urgent interim relief. Interim relief, but the learned counsel for the respondent bank raised the point of maintainability. Accordingly, raise the point of maintainability and also draw the attention of this court to the order passed by the learned tribunal.
May I, my lord's kind leave, my lord? Now the matter has been called.
Learned NCLT dated 16 December 2025, wherein liberty is granted 16/12/2025, wherein liberty is granted to the petitioner for moving any application, if required, in connection with the successful implementation of the resolution plan. The counsel for the respondents also raised the objection with regard to bar under section 231 of the Insolvency and Bankruptcy Code 2016, as well as also draw the attention of this court to the rule 38 and 39 of the IBBI Insolvency Corporate Persons within bracket regulation 2016. Full stop. Until counsel for the find that the matter is to be heard on merit if as the
Malaj, can I pray for Wednesday? Malaj, sorry.
Yeah, my lord, Wednesday I will have some difficulty, my lord.
Let the matter appear on 25, Mr. Karmaka.
Lord, 25th is Lord.
Wednesday.
It's Wednesday, Mr.
Lord,
Karmaka.
Wednesday I'll have some difficulty, my lord. Either Tuesday or Thursday.
Let it be on Tuesday then, Malaj. Let it be on Tuesday. We'll come, Malaj. We'll come and do it.
The same.
Lord, Tuesday, Lordship's pleasure, my lord, to fix a particular time, my lord.
Under the heading urgent motion.
Great.
Time cannot define.
Great. Well, that will do. Lord, only one humble prayer, Lord. If in the meantime it's only about a matter of 3 days.
No, Malaj. So maintainability.
Else, Lord, I'll be nowhere. If not this performance guarantees, Lord, invoked, Lord, I'll be nowhere.
The court is here on Monday. No problem. Mr. Banerjee is also there.
Malaj, I will follow Malaj the law to the T. Whatever is the law, I'll follow to the T. I can assure your lordships that. Malaj, I am a creature of instructions. Your lordship knows it. Malaj, I'll follow law to the T.
Lord, if some protection in the meantime, Lord, I will.
No, Malaj, a question of maintainability is involved here, Malaj. I am ready with the. If my learned would have served earlier, Malaj, I would have come physically and Malaj, I would have done it.
Lord, today by itself, Lord, I got that, Lord, liberty, Lord, as early as possible.
No,
I had served.
I'm so good.
Grateful, Lord. Grateful to your Lord.
Yes, next.
Regarding the arms license petition, actually obtaining the arms license and it is within the time of the earlier official your lordship and see number 44 below. Justice Honorable Justice version to pass the order. Direct
Page
44 below. To consider the application for the granting of the arms license of the petitioner.
Correct.
In spite of the directions, he reject the order.
Where is the rejection order? 54. Subject mentioned above, this is to inform you that your prayer or issuance of new arms license cannot be considered as the superior of police. Birbhum raised strong objection from the police point of view. Yes, then.
After the order passed by the honorable court, he called the petitioner for the hearing as per the direction. There in the petitioner submitted by the necessary of the arms license. In the written submission, kindly see the case number 49. Kindly see. And we accept the reason that he actually service employee of the security guard in the company, and company required the arms license for the service.
Who are you?
I'm a petitioner.
You are the petitioner. What is your occupation? You are the security guard. Yes. Security. All security. So your company will provide the arms. How you will get the license?
Yes, your right, that depend on the need of the arms license.
Where is the document? You have been appointed by the company, and the company has requested you to obtain the Page 50. What is that 50?
Guard company.
Madam, you are having the company or you're working in the company?
Under the
company, correct. So where is the request made by the company to you obtain the license for possessing the license gun or license rifle or license pistol? Where is the letter of the company? So the arm license cannot be granted as a license of the excise liquor. Then
that which is that not circular salary of the employee as a security guard depends on the license. That if you have a arms license.
That's why where is your appointment letter? Your appointment letter says that yes, yeah, for that purpose you require the arm license. Where is that? Where is your application for grant of arm license? Where is your application? Where is your application?
Page number 60, Miller. Page number 60.
This is a format.
The year of 2020, 2020 brought back 2023 year. And as per the arms license rules, it is supposed to be disclosed within the 90 days year. Petitioner failed to, I'm very sorry to say, Lord, it is the petitioner failed to pay some unofficial fee to police officer to satisfy.
Kindly come to page 17. Kindly come to page 17. What you are submitting or what you are mentioning in the application form. Need for the welfare for self-protection, not for the job. Then
So, Miller, kindly, that time, Miller, kindly appreciate that time petitioner do not appoint as a security guard that time. So, at the time of the order passed before the High Court and at the time of the hearing before the DL, petitioner submit all the required documents. Kindly consider that. We know any please state anything.
the petitioner has applied for grant of arm license before the. To whom you have applied for? Before the. To whom you applied for? DM? Before the respondent number 2. But the respondent number 2 had not considered the application for grant of arm license to the petitioner. Accordingly, petitioner has filed a writ application before this court. Before this court being WPA number 16489 of 2023. By an order dated 19 July 2023, this court has disposed of the writ application by directing the respondent number 3 to consider the representation of the petitioner in accordance with law within 6 weeks from the date of communication of the order after giving an opportunity of hearing to the petitioner. The counsel for the petitioner submit that after the order passed by this court, the respondent number 3 has passed the impugn order dated 4th of September 2023 by rejecting the request of the petitioner for grant of arm license on the ground that the Superintendent of Police Birbhum raised a strong objection from the police point of view. This court finds that the district and the respondent number 2 has rejected the request of the petitioner on the ground of the objection raised by the Superintendent of Police, Birbhum. But the reason of objection by the police authority has not mentioned in the impugn order, and the impugn order passed by the respondent number 3 also not having any reason or findings. Considering the above, the impugn order dated 4 September 2023 is set aside and quashed, and the respondent number 3 is directed to consider the request of the petitioner afresh, giving an opportunity of hearing to the petitioner, and if the respondent number 3 is relying upon any report of the police authority or any concerned authority, the report shall be served upon the petitioner and the petitioner liberty to deal with the said report. The process for the respondent number 3 is directed to complete the process and pass the reason in speaking order within a period of 6 weeks from the date of receipt of this. Disposed of. Next. Huh? 11? Which 11? Disposed of. Give your name. I have already passed an order to consideration. Give your name.
Considered and disposed of.
Rejected, but you have given the police has raised objection. What objection? The copy has not been given. Now reason has been assigned. So reason assigned.
Let me.
Yes.
The beg to appear for the state respondent, my lord.
My lord, I am appealing for the petitioner. The petitioner is a student who is pursuing his masters and is also a patient of chronic kidney disease. Is undergoing dialysis 3 times a week. My lord, and urgently needs kidney transplant. I had approached the authorization committee for approval. Without that approval, I cannot have the transplant. My lord, that application was made in July. It's pending since then.
In the list, your name is not there.
My name is there.
The name there is your name is there.
My name is there in the list,
Where
but
is
they
that?
have not approved.
Where is that?
My lord, it's in page number 54. My lord, the list which they have published in the month of January 2026. My lord, page number 54.
Pass.
That, my lord, the
54.
54 is the provisional list of patient. They called us for the hearing. My lord takes up page number 56, serial number 16. The name of the petitioner appears.
Serial number
16.
60.
16, my lord. 16.
What is your name?
My lord, Aisha
Sheikh.
Ardent Tiger Hospital.
The Amina Tiger Hospital. Yes.
If my lord takes up my application, which is there in page number 53. My lord, I have submitted the application on 14th of July.
Who is the donor?
My lord, the donor
name is provided.
Yes, is provided, and I have also made him a party. My lord,
party?
phone number 7. My lord, I have all the documents.
Donor, he's helping you, and you made a party to the.
For my respondent, my lord, with his permission, my lord.
My lord, I am appealing for the state, my lord. Presently, I do not have any instruction, my lord. My lord, kindly come, page 100, my lord. To obtain the NOC, has to obtain first, my lord, the domicile certificate, my lord. I do not know they have already obtained it or not.
Domicile certificate of?
My lord, kindly come page 100, my lord. This is
100?
issued by the hospital, my lord.
100?
Page 100.
Yes.
I am reading my lord, second paragraph. Mr. Obhijit Das has been presented to us as the organ donor of the recipient and is medically evaluated and found fit to donate organ. The recipient, proposed donor, and the legal guardian of the donor mandatorily need to obtain domicile certificate from the administrative officer, Government of West Bengal, of the rank of SDO to confirm their identity and residential address before.
Under which provision of the law? Which provision of the law domicile certificate is required?
My lord, I
It is
have
the-
that certificate. My
under
lord,
the
kindly fix the
Transplantation of Human Organs and Tissues Act 1994 and its amended rules 2014. To confirm their identity and residential address before they are referred to the competent authority under the Government of West Bengal for issuance of NOC stroke order for undergoing organ transplantation as per the said act. So, my lord, I do not know, my lord, whether they have already the said certificate or not, because in the petition it is nowhere stated, my lord.
My lord, takes up page number 98 and 99. My lord, with my application, I have submitted all the documents, my lord. The domicile certificate are annexed with the petition.
This is Purnima Das, the wife.
The guardian of the donor, and page
Wife.
number 99.
99 is Aisha Sheikh.
Purnima Das is the wife of the donor.
Yes.
He is the guardian.
She is the guardian. My lord, I have submitted all the documents. It's pending.
So she is the daughter. Purnima Das, how the Purnima Das?
My lord, wife of the donor, Obhijit. My lord, Mr.
Wife of the donor?
Mr. Obhijit.
Abhijit. Who is the donor?
My lord, Obhijit Das, one Obhijit Das. My lord, there's a checklist which appears on page number 60. My lord, if my lord takes up page number 60. My lord, I had submitted each and every documents which they have sought for.
NOC of foreign parents. Prospective, yes. Yeah, you do one thing, you take instruction, all the documents are
Or
there.
alternatively, my lord, kindly direct the director of medical education, my lord, to consider the representation and
Who is the authority?
Respondent number 3, my lord.
Director of Medical Education, my lord, he is the chairman of the authorization committee. My
He is
lord,
the competent authority, my lord.
my lord, respondent number 3.
Secretary.
No, the director of medical education and ex officio secretary, yes.
My lord, a similar kind of matter was taken up by the coordinate bench. My lord, in that event, my lord, the honorable coordinate bench has directed. My lord, if I may hand over. If my lord takes up page number 14.
Page number?
My lord, in paragraph number 14, page number 4.
Huh?
Page number 4, paragraph number 14. My lord, in this event, there was some allegation of financial transaction. My lord, as the authorities have failed to confirm financial transaction between the parties, and as both the parties have filed respective declarations on affidavit, accordingly, the instant writ petition is disposed of with the observation that the patient, who is the husband of the petitioner, be permitted to proceed with the process of kidney transplantation from the donor, provided
Where is the act? You're not having the act.
No, my lord.
Because I had disposed of two matters. In that case, the parties have challenged the order of the authority.
My lord, here in this case, no order was passed.
That's why. So then that has to be decided by the authority.
My lord,
The
the
representation-
time frame be
Yes.
fixed, my lord, because undergoing dialysis 3 times a week, my lord. I urgently need the transplant.
Yes, that's true.
Who is the donor?
My lord, donor is Obhijit Das.
Now, how is a relative?
He's
Not the relative, my lord. Petitioner is Aisha Sheikh.
My lord, he is related to the petitioner's mother.
How?
My lord, in some way he is related to petitioner's mother.
Neighbor.
He is appearing for the respondent 7.
So then you have to affirm the affidavit before the executive magistrate. Then the police inquiry has to be considered
All the affidavits have been submitted.
where the police inquiry was conducted, whether there is any monetary transaction is involved in the matter.
My lord, those the authorities
That
are
is
supposed
required.
to carry out, my lord.
That is required.
We have filed the affidavit, my lord. The affidavit is annexed in page number 48, my lord.
48.
My lord. My lord, the donor has submitted his affidavit, page number 48.
You do one thing, you take instruction. You take instruction. What is the
In that
stage?
case, my lord, we need some time, my lord, because during the process of election, my lord, all the officers are very much busy, my lord. My lord, kindly direct the
Where is the
director, my lord.
affidavit of Abhijit Das?
My lord, page number 48. My lord.
I have already talked with the authorities, my lord, but it will take some time, my lord. They have said that, my lord. ইনস্ট্রাকশনে আনতে পারি কিন্তু না ওরা বলতে চাইছে আমাদের সময় লাগে ওরা যদি বলেন সোমবার আমি দিতে পারবো সেটা তো ওরা করতে পারছে না আমার কোনো অসুবিধা নেই আমার মনে হয় তোমাদের রিপ্রেজেন্টেশন কনসিডার করলে বেটার হতো ঝুলিয়ে রাখবে টাইম ফ্রেম করে যে কোর্ট বলে কেন টাইম ঝুলিয়ে রাখবে
But it has to be investigation is to be inquiry is to be carried out.
My lord, I have filed the application in July, month of July. They were supposed to carry out all the investigation. They call after carrying out the investigation and verification. They call us
Police whether the monetary transaction is involved in there or not.
Do not have
That is a serious
yes.
thing is to be
They
considered.
have not
They have not alleged that there's some.
They not alleged, but that the court as well as the authority has to be careful nowadays.
My lord, the respondent number 7 is appearing, my lord. My lord may inquire from respondent number 7.
Which place you are residing? Your address is?
My lord, in Park Circus.
And the donor is residing where? Dakshineshwar. Then the report is to be taken into consideration. Who? Victim.
None.
Mother of the patient is? The petitioner has filed the present application praying for direction upon the respondent number 3 to consider the request of the petitioner request of the petitioner for grant approval for renal transplantation of the petitioner who has been diagnosed with END stage renal disease and is in urgent need of kidney transplant in accordance with. Counsel for the petitioner submitted. What is the age of the petitioner?
The petitioner is
28, my lord.
28
Petitioner
years old.
is the age is aged about 28 years and is presently pursuing the MSc Zoology from Baliganj Science College. The petitioner is diagnosed with bilateral chronic renal perimenal disease and is continuous under medical treatment with whom? Which hospital?
My lord, R.N. Tagore Hospital, Rabindranath Tagore.
With Rabindranath Tagore Hospital.
Now it is Narayana Health.
My lord, respondent number 8.
With the respondent number Narayana Multiplicity Hospital, Kolkata. Police. The private respondent, being the neighbor, has private respondent number 7, Abhijit Das, being the neighbor, is ready and willing to donate the kidney to the petitioner and has submitted all the documents, including the affidavit executed before the magistrate, and the matter has been placed before the committee for consideration, but till date the authorities are not considered with regard to transplantation of renal transplantation. Learned counsel appearing for the respondent raised objection and submit that the Narayana Hospital. Where is the page that domicile certificate is not there?
100, my lord.
The Narayana Hospital has given a certificate. Wherein it is mentioned that the donor has to obtain the domicile certificate from the administrative officer of the government of West Bengal. The petitioner has brought to the notice of the domicile certificate of the wife of the donor issued by the concerned authority. Counsel for the petitioner submitted. The petitioner has submitted all the required documents to obtain approval from the competent authority for renal transplantation, but in spite of the same, till date the application has not been considered. Consider the submission made by the counsel for the respective parties. This court find that the petitioner has made an application before the. Where is your application?
It's in page number 53.
An application before the respondent number 3.
Respondent number 3, my lord.
Respondent number 3 on 14th of July 2025, but along with all documents, but till date the request of the petition has not been considered. Considering the above, the writ petition is disposed of by directing the respondent number 3 to consider the representation submitted by the petitioner dated 14th July 2025 along with the documents and the affidavit submitted by the donor and his wife, and to take appropriate decision for grant of approval for renal transplant within a period of 6 weeks from the date of receipt of this order. The petition is disposed of.
She is suffering from 5th stage of the kidney failure, my lord. And we
In a period of 4 weeks.
Grateful, my lord.
Deeply obsessed.
Your Lordship, Your Lordship, item number 34.
Huh?
Item number 34, Your
Ah.
Lordship. The interim order is to be expired by Monday, Your Lordship.
Monday.
Yeah, the matter was made returnable on 18th March. The matter is running in the list,
Ah.
but Your Lordship, the matter could not be taken.
Item number 34. 34.
On Monday, I'm the heading extension of it.
Huh?
On if the matter can
Monday, come on Monday. Monday the court is there.
Your Lordship, the matter could not be taken. In case the matter is not
Monday mention it. Till Monday. Okay, Monday you mention that. If it is not in the, it will be in the list. If it is not taken up, you mention, I will extend the time. There's no problem. Yes.
Next one.
Which matter?
Item 23.
Come tomorrow.
After 1 year they're filing, they served on us yesterday. Kindly give this 4 weeks time Manu, to file the
Record 23. The respondents have filed affidavit in opposition after serving the copy to the land counsel for the petitioner. Counsel for the petition press for time to file reply. Let affidavit reply be filed within 2 weeks. After serving the copy to the land counsel for the respondent, list the matter on 16th April under the same heading.
interim order is till the 24th.
24th of this interim order is extended till 20th April 2026 or until further order, whichever is there. Next.
My lord.
Origin side call.
My lord, in my case, my lord, should I come and say Monday on 29? Subject to my lord's pleasure, the interim order is still up to Monday.
Come on Monday.
Very. Monday my lord, morning I should mention.
Come on Monday. If it is not taken, then come on Monday. If it is not taken, I will, before rising in the court, it will be accepted.
Extremely good.
I think careful personal abuse. They're present. You are petitioner. Who is for the contemner?
Because when you lordship was of the view that it is obviously consequences. That's why I'm saying, but
Okay.
not all matter also at the end, but so that
Before rising, you mentioned.
very good.
But may I have your lordship's kind leave to mention item number 191 of the dailies list. Lordship, last year, due to fire outbreak in a restaurant, at a restaurant in central Kolkata, 14 lives were lost for lack of fire safety infrastructure and mandatory fire safety norms. This is the same locality. But Mine's ground premises has been occupied by the restaurant, unauthorized commercial structure.
Who has let out? Who has given the ground floor on?
They are the unauthorized occupants.
How?
I have occupied the property. After coming to the ground without any fire safety certificate, which is the mandate and West Bengal Fire Services Act 19.
Correct.
Just look at behind a very much congested local.
Behind the?
Your lordship.
So what you want?
But the apparently any untoward incident may cause serious inconvenience. So grateful, Your Lordship. So
Yes,
grateful.
call the list. Yes, what is the compensation? What compensation can be granted?
I appear on behalf of the plaintiff, Your Lordship.
Caring for?
The plaintiff, Your Lordship.
Yes, what compensation you want? They have compromised that there is an apology.
There's an apology, Lordship, but we have submitted that we are not, it's not a compromise decree at all.
But no compromise, but apology. But what compensation?
Apology accepted. We are at Your Lordship's hand, whatever Your Lordship deems.
I have damage of pay of rupees 1,000 each and cost of 5,000.
Grateful, Your Lordship. Grateful.
1,000 each and 5,000 cost.
For the respondent were 3.
All three. 1,000 each, 3 defendants, and 5,000 only one.
Obliged, Your Lordship.
I appear for the respondent number 4. This is a classic case where Your Lordship, without the matter even being moved for a day, only with the filing, the parties have settled. With the pressure of this court, parties have already settled.
Pressure of the court without.
That is already on record. Settlement is on record, Your Lordship. We have signed.
So what do you want? Only disposal, dismissed?
Disposal of the writ on the basis of the TOS.
Decree in terms of this.
Disposal of the writ on the basis of the TOS.
Record done.
Grateful, Your Lordship.
The GA1 you filed?
Yes, GA1.
Who has filed the GA1? I have the petitioner. The petitioner has filed an application being GA1 of 2026, disclosing the compromise entered between the parties, disclosing the terms of settlement entered between parties, and submit that as the parties have settled the dispute by entering into terms of settlement, and as such the petitioner did not want to proceed with the matter further. In view of the above, WPO number 71 of 2026 disposed of, according GA1 of 2026 also disposed.
Grateful. Grateful. Great.
This is a probate application, my lord. The
I was examining my witness
to-
the chief had mentioned to Your Lordship that on 19th and 20th,
To the order,
the witness had some.
Nah, you mentioned on 19, 20 you not mentioned. 20 your witness will
My
be.
lord, only see these 2 orders, my lord. They do not want to proceed with the matter. My lord, July 22nd, 2023 order. It is made clear that the date fixed, if defendant fails to adduce witness, the evidence on side of the defendant will be closed. 22nd July. Then again, this started from 2023, the examination, 2023 probate application, my lord. 9 days, they have taken me for cross-examination, then they are with their witness. And 12 November 2025, your lordship sees the last date. Now it is last point. It is made clear that no further adjournment shall be granted to the defendant. And today, the 2 days were fixed in front of them. Now your lordship decides what to do, my lord.
Closing.
Just a few more minutes. I just need one more session.
Nothing. Go and take the order from the appellate court. The court is not having time. The court is fixing the date. On the date of fixing, you're not coming. So what can be done? This court find that the matter is of 2021, and time and again this court has fixed the continuously date for examination of the defendant witness. The matter was appeared was fixed on 4th of December 2021. The examination chief of the defendant witness could not be completed. Accordingly, chief was deferred. And the matter was fixed on 19th January 2021 and 21st of January 2021. But 21st of January 2021, the chief was not completed, and the case was adjourned till today. Until 19th of March 2020 and 19th of March 2020, and this court has fixed the matter especially fix the matter for examination of the defendant witness on 19th and 20th March 2026 at 3 p.m. Today, when the matter is called, again the defendant is praying for time. This court finds that the defendant is dragging the matter instead of making any endeavor to dispose of the matter. Accordingly, the examination chief of the defendant witness is closed, fixed for argument. Nothing. Go. I want nothing. Maybe difficulties. Sorry, January I have fixed and today we are the March. Yes, call the nurse.
Was also coming up.
Yeah, they're the Kejriwal, they're not the ED.
Kindly just give one. Kindly. Kindly. The testimony suit is being contested.
Testimony, but see the condition of the court. Then, okay, pay the 1 lakh rupees.
No.
I will allow you to pay the 1 lakh rupees in cash.
I sincerely bow down, I see,
After the order passed by this court, the learned counsel for the petition time and again praying for fixing any other date so that he can examine the witness. Considering the submission made by the counsel for the defendant, the order is recalled. And this court is find that one further opportunity is given to the defendant for examination of the witness. Let the matter be appeared on 9th of April to 3:45 p.m. with the subject to payment of cost of 1 lakh to the State Legal Service Authority. Yes, next.
I'll pay cost. Kindly, just some, just as an observer. Just kindly.
No. No.
We'll finish it off in one session. No further.
Sir, I am totally fed up with your all this witness. How many questions you have put? 500 question has gone.
It hasn't got to 500.
Nothing. You pay the cost. Kejriwal, they are having so many business. Pay the cost.
They are exporters. They are exporters of fish in foreign countries.
Yes, who is appearing? Who is appearing for the? Who is appearing for the item number 4?
Item number 4, I am appearing under the plaintiff.
Yes.
On the last occasion on 11th of February, Your Lordship can see that order. Your Lordship had allowed striking of the names of the defendant numbers 2 and 3 on their application. But in that view, we have amended the plaintiff served on the defendant number 1, who is now the sole defendant. But since they are not appearing today, there may be an order subject to what also from Your Lordship that if they want to file an amended written statement, because in the appeal court, from an appeal against the order of injunction, they had filed the written statement subject to allowance by the learned honorable division bench of So in case pursuant to the striking of the names, if they want to file any additional written statement.
But today is the bar resolution, what can be done?
So that order can.
So and so appearing for the plaintiff, none appears on behalf of the defendant due to the bar resolution. The case is adjourned. Let the matter appear on May. Which date? Monthly combined monthly list of May 2026. Next.
But I oppose the application, Minister.
Yes.
But this is for rejection of my plaint.
Where is the other side?
This side, Mr. Samrat Sen was appearing earlier.
Bar resolution.
Led by Mr. Mitra.
You are for the petitioner.
Other side, no.
As none appears on behalf of the defendant.
Sure, not next Friday, I will not be here. Next Friday, I will not be. Kindly adjourn.
None appears on behalf of the defendant. Agony case adjourned. Let the matter appear.
Supplementary leave needed.
On.
Should we leave it?
7th April.
I will, let some subsequent developments also can give us leave to file a supplementary.
What double? Bring that, we will see to that. Because other side is not here.
Yes.
Next.
Here for the two matters appear together, 6 and 7, relating to the will of the same testator, my lord.
in item number 6, that is PLA 323 of 2022, my lord, I am for the applicant, I am for the propounder. In 320, that is 7, my lord, I am for the caveat.
Yes.
The last occasion, my lord, 18th February 2026, you passed an order whereby your lordship has directed that since in the item number 7, I have already filed my caveat and affidavit in support of caveat. A tested inventory number should be issued, which I am informed the department has complied with, and testamentary number has been refused. Now, my lord, in the matter of item number 6, which is of 2022, PL of 2022, they were to file the caveat in affidavit in support of caveat. I am informed that the caveat has been filed, that they have filed the caveat. The only thing is, my lord, they have served one affidavit long back without filing the caveat. I think, my lord, before filing the caveat, an affidavit in support of caveat cannot be taken on record. So, my lord, I do not know whether after filing of the caveat, they have filed the affidavit in support of caveat in department or not. That is to be seen from the records, my lord. And if they have filed, my lord, let them serve it on us.
So your PLA is
My
TS
PLA is 2022.
2022.
The 323 of 2022. That is, I'm the propounder.
Okay.
I'm the executive.
Okay. PLA 320.
In 320 of 2018, I am for the caveat.
You are the caveat.
Your lordship should remember that matter.
Yes, yes, I did.
Revocation, your lordship passed an order for revocation.
दूसरा वाला नहीं है, कोई कैविएट है उसमें देखो. है affidavit in support of caveat.
In 2022 matter,
Yeah, 2022.
so they have filed it.
Ramji Singh.
Ramji Singh. Only thing is, my lord, this affidavit in support of caveat, one they have served on us long back before filing of the caveat.
No, this is 23 to February 26.
Yes, so, my lord, I am not sure whether they are relying on the same version of the affidavit. So, your lordship may kindly direct them to serve this one on us.
You're not been served.
One.
No, this 26 affidavit is not served.
This 26 affidavit is not served on us. So let them serve it on us, and simultaneously the department may issue the testamentary number.
They already issued, I think, so no? Not issued.
No, in
Testamentary.
In 2018 matter they have.
हाँ, इसमें नहीं दिया.
2018 matter they have.
It is found that in PLA 323 of 2022, the caveator has filed affidavit in support of caveat on 23rd of February 2026. Police and counsel for the objector and petitioner submits that he has not received the affidavit in support of caveat affirmed on 23rd of February 2026. In view of the above, the caveator, the learned counsel appearing for the caveator is directed to serve the copy of the caveat affirmed on 23rd of February 2026 to the learned counsel for the petitioner within a week from date. Full stop. As the caveator has filed the affidavit in support of caveat, accordingly, department is directed to assign the testamentary number in connection with PLA 323 of 2022 and to place the matter before this court on 9th April 2020. That's all.
Next question perhaps I'll be.
Yes, if the both will completed, then issues will
inspection and issue.
Yeah, discord and inspection and issues.
It will so.
So why discord was assigned?
It is an assignment. Your lordship knows the background of the matter, because your lordship has heard the revocation also for a long.
I will carry the total file.
It is that matter, my lord.
Yes, yes, yes.
Caretaker versus wife.
That marriage certificate has not relied.
Yes, yes.
Yes, next. नहीं है छोड़ो. None appears. None.
My lord, I appear for the plaintiff responded in an application for rejection of plaint. My lord, this is Nulal Bhos Talmichi, my lord, offshoot of that, of the probate that was granted, my lord, appeal court.
Yes, two question was put to the
Yes, so now
you have to give
new
answer.
it's not really a new question. They're trying to really, on a disputed question of fact, seeking to have the plaint reject. My
Not
lord, yes, my lord, will kindly keep it any day, my lord.
Not today, not today.
Not.
Next.
Problem.
Not today. Is any matter? Both parties are there? No. Nothing. Yes. Call. उनका एंट्री मोटर किस में है? Who? Call the item number 22. आदित्य विक्रम बिरला. You are up. क्या नाम है आपका?
परिवेश शुक्ला.
परिवेश शुक्ला. Yes. Have you received notice?
माय लॉर्ड, एक्चुअली इसमें जो भी इन्होंने बोला वो मैं डिनाई करता हूँ. ऐसा मैंने कुछ पोस्ट नहीं किया है.
हाँ.
मेरी कंपनी और मेरा वेबसाइट ये सब कुछ इनके ही कंट्रोल में है.
किनके कंट्रोल में?
पिटिशनर के कंट्रोल में है, आदित्य विक्रम बिरला के कंट्रोल में है. एक्चुअली माय लॉर्ड, जो राफ्ट मोटर्स लिमिटेड है वो मेरी कंपनी, हमने ही फाउंडर है हम लोग. और मैंने फाउंड किया था 2019 में. और इन लोगों ने जो तो फर्जी डॉक्यूमेंट्स वगैरह बना करके मुझे कंपनी से मुझे ही बाहर निकाल दिया विदाउट सिंगल रुपीज पे किए हुए. और जो मेरी वेबसाइट है माय लॉर्ड, तो मेरे ही कंपनी में एक मनीष कुमार जो कि जनरल मैनेजर की पोस्ट में काम करता है, उसने ही डेवलप करी थी. और वो अभी भी कंपनी में, बट वो ऑर्डर जो है अभी आदित्य विक्रम बिरला के फॉलो करता है, मेरी बात सुनता नहीं, तो उसके ही कंट्रोल में सब कुछ, आईडी पासवर्ड एवरीथिंग उनके ही कंट्रोल में है. और
from the document to that year, that it's his own site, and he's mentioning it. And when it's in LinkedIn, man. This is a personal.
आपका where is your affidavit? Where is your affidavit?
माय लॉर्ड, ये रिप्लाई मैंने पूरा बना करके रेडी कर लिया है और इसको मैं सबमिट कर दूंगा अभी.
करिए. साइन किए?
लेकिन इसका एक जीरोक्स भी लेना पड़ेगा. ओरिजिनल है, जीरोक्स नहीं लिया. साइन वगैरह सब कुछ कर लिया है.
एफिडेविट हुआ है? हाँ,
सब कुछ हो गया माय लॉर्ड. सिर्फ इसको स्कैन करके एक कॉपी, 2 कॉपी निकालूंगा, एक अपने लिए, एक आपके लिए, एक इनके लिए. वैसा कर दूंगा माय लॉर्ड. ये
only case if you have one states when the lordship had directed that displaying of any kind of defamatory statements should not do in the last order. But this is what the lordship found.
Yeah.
This is Parivesh Shukla. My learned friend's name. Where my founder of Calcutta and the share transfer. This was subsequent to an order already passed by your lordship preventing him from making a defamatory statement. Now, by the order of 4th February, your lordship has said you should not display any further. But this is still on display. I want to let him give his affidavit. The lordship kindly tell him to at least remove that.
माय लॉर्ड, मेरी वेबसाइट उनके ही कंट्रोल में, और जो जिसकी ऑर्डर की
कंट्रोल में है,
आदित्य विक्रम बिरला के कंट्रोल में है. उनके
ये आपको पब्लिश कैसे हो रहा है?
ये नहीं हो रहा है पब्लिश. इसमें आप देख लीजिए, कोई भी डेट नहीं है. ये पुराना है, फेब 2024.
ये नहीं, पहले अभी बीच में हुआ था.
26 नवंबर को मैं यहाँ था. उसके बाद से कोई भी कुछ भी पब्लिश नहीं किया है. आप कोई भी ये डेट नहीं दिखा रहे, सिर्फ पुराने पोस्ट को उठा करके आपके पास दिखा रहे हैं. उसमें कोई भी डेट नहीं है, आप चेक कर लीजिए. पुराना है फेब. इसका मैंने पुलिस कंप्लेंट भी किया हुआ है. इन्होंने जो मेरा वेबसाइट सब कुछ हैक करने के लिए पुलिस कंप्लेंट भी मैंने किया हुआ है. इनफैक्ट आदित्य विक्रम बिरला को मैंने व्हाट्सएप पे भी स्क्रीनशॉट भेजा कि सर ये आप कर रहे हो क्या, तो उन्होंने कुछ रिप्लाई भी नहीं दिया मैंने मुझे. उसका भी मैंने स्क्रीनशॉट सब कुछ लगाया हुआ है रिप्लाई पे. माय लॉर्ड, अभी मैंने आपको एक पेपर पास किया है। इन्होंने मेरे शेयर जो है एक 28 मार्च 2024 की डेट का एक फर्जी डॉक्यूमेंट, फर्जी एग्रीमेंट स्टाम्प पेपर के ऊपर नोटराइज किया हुआ उस पे इन्होंने किया है। और वो स्टाम्प पेपर
না চলছে আমি বললাম তো সাহেব বলছে আর্গুমেন্ট করছে সাহেব
अगेंस्ट में एलिगेशन है कि आप जो है कोर्ट के डायरेक्शन के बाद भी आप जो है पब्लिकेशन कर रहे हैं, ठीक है। परवेश शुक्ला का नाम से .com किसके नाम से है? आपके नाम से है?
मेरे नाम से है।
ठीक है ना, आपने उसको विड्रॉ कीजिए, क्यों नहीं कर रहे हो आप?
उसका पूरा कंट्रोल जो है मनीष कुमार है, जो कि राफ मोटर्स का जनरल मैनेजर है। उसने ही मेरी वेबसाइट को डेवलप किया है। वो काम करता है राफ मोटर्स। राफ मोटर जो है
आदित्य, आपको आपने रिप्लाई में दिया है?
हाँ हाँ दिया है, दिया है।
कौन सा पैराग्राफ बताइए, कौन सा पैराग्राफ में आपने लिखा है?
ये रिप्लाई
कौन सा पैराग्राफ में आपने लिखा है? वो गवर्नमेंट जो भी बोल रहे हैं आपने उससे आप अपना एफिडेविट में लिखे हैं?
थर्टीन पेज में 10 नंबर पॉइंट।
मनीष कुमार, मनीष कुमार?
जी जी।
मनीष कुमार कौन है?
ये जनरल मैनेजर राफ मोटर्स में अपॉइंट हमने किया था। जब हम लोग कंपनी चला रहे थे सर, तो हमने अपॉइंट किया था, इसी ने डेवलप किया था। आदित्य विक्रम बिरला ने जब चार्ज ले लिया तो ये उसके अंडर में काम करने लगा। हम लोगों का कोई भी रिप्लाई कुछ भी रिसीव ही नहीं करता है और उनके ही डायरेक्शन पे काम कर रहा है, उनके साथ में। और माय लॉर्ड, मैं ये जो बोल रहा हूँ, ये वेबसाइट ये सब कुछ करना इनके लिए बहुत छोटी बात है। मैं बड़ा पॉइंट बता रहा हूँ कि अगर वो कर सकते हैं तो इनके लिए क्या बात है। जो स्टैम्प पेपर 28 मार्च 2024 में प्रिंट,
काम कीजिए, अब ये कब फाइल करेंगे? आज करेंगे?
मेरा रेडी, मैं इसका जिरोक्स करवा के मैं फाइल करवा दूंगा।
जेरॉक्स करेंगे तो आपका मैं फिर परसों रखता हूँ, परसों लेके आइए।
जी जी जी।
मंडे ये भी दे दो। The alleged contender is present in person and submit that his affidavit is ready but could not be Xerox, and he prays for a day's time. In view of the above, the case is adjourned. Let the matter appear on 23rd under the heading to be mentioned. Monday आइए और लेके आइए।
Yes yes.
Obliged.
Item number 19, my lord. My lord, I am for the contender. I am appearing in person, my lord. Very unfortunately, my lord, in the pending application, my lord, the alleged contender 1 to 6, they have filed a affidavit for calling on the 4th of February 2026. I am submitting, my lord, such type of persons of such type of application may kindly be dismissed.
Let the other side come. We'll see to that.
The lordship kindly take it on Monday.
Yeah.